Delivery of orders.
Court has formulated 3 points of determination, and it has been answered as follows. A, in this case, the election petitioner has been able to prima facie show that in respect of the ground of suppression of educational qualification, the election petition is not lacking in material particulars and particulars of corrupt practice or undue influence. And accordingly, the election petition is not liable to be rejected under Order 7, Rule 11 CPC. The point of determination number A is answered accordingly. In the same context, based on the manner in which the statement made in election petition are verified in the verification affidavit in support of the election petition, and affidavit under Rule 94A of the 1961 rules do not entitle the election petition to be rejected under Order 7 to 11 CPC. In light of the discussion above, there is a cause of action for the election petition, at least in the context of suppression of educational qualification. Therefore, as there exists a cause of action on at least one ground, which is suppression of educational qualification relating to diploma in civil engineering, the election petition is not liable to be rejected. Interlocutory application stands dismissed.
Obliged.
There are some corrections, last moment, you can just go through it, but there are some corrections.
48.
So,
48.
in view of the ratio laid down in the case of K.D. Sharma, the court is inclined to reject this writ petition on the ground of suppression of material facts as the learned senior counsel for the intervener has asserted. Those facts have a bearing in this case. Resultantly, on applying the doctrine of merger and taking note of the fact that there is no challenge to the appellate order dated 21/2/2022, the writ petition stands dismissed. Moreover, suppression of material facts and non-disclosure of such facts, specifically the existence of appellate order dated 21/2/2022, this writ petition stands rejected. Under this circumstance, a cost of ₹10,000 is imposed, which shall be handed over to the Guwahati High Court Legal Aid Committee. It is clarified that the writ petition was heard on preliminary issue of maintainability raised by the learned counsel for the intervener, and as such, the merit of the case of the petition has not been gone into and not adjudicated.
49 to this potential.
It's legal lawsuit.
Yes,
I- My lord, later on, I have seen my lord, in my petition, my lord, after hearing my lord, some defect is there, my lord, inadvertently. My lord, actually is the respondents is to be made in secondary department. But my inadvertently is.
no, not that. This is a matter relating to that DLC.
DLC.
On that day, I took a view that the matter be referred to a larger bench. But in fact, that would not be necessary because of the fact that this bench and as well as the coordinate bench of this court
Right.
have taken a consistent stand, and they have dismissed the applications for this reconsideration.
Right.
There are 3 judgments of the Supreme Court, all authored by a 3-judge bench,
Right.
where it says that that for a DLC, the compassionate scheme, which is an operation,
Right.
that on the date of death and constitution shall prevail.
Right.
Therefore, I am dismissing this petition.
My lord, I also, defect is there, my lord, so I may be allowed to withdraw and file liberty will file.
No, liberty we can't give because since I am dismissing it, otherwise also, you can just withdraw it, but without liberty.
But one thing is that if I'm going to dismiss, if I'm going to in higher court, then my lord is defect is come. So my lord, either or lordship, allow me 10 days to file miscase for
No,
correction.
you see, filing of
But
correction-
respondents is wrongly my lord, my lord.
No, but we are not going on that.
My lord.
defect or non-joinery we are not taking because the deputy commissioner is the DLC
my lord.
and the SLC, they are both present in this case.
One my lord, order was, I am my lord, taken my lord. But in this judgment, my lord, Honorable Court, my lord, held that, my lord, paragraph 14, my lord,
But Mr. Bora,
my lord,
you see, when the writ petition itself is not maintainable
my lord,
on merit,
my lord,
when because there are too many defects.
yes, ma'am,
There is one another major defect,
my lord,
which I may not point it right now. In respect of the DLC,
my lord,
sorry, the scheme of the compassionate appointment. Now, with 3 Supreme Court judgments of a 3-judge bench,
my lord,
can you alter the position even by amending that the scheme which is prevailing on the date of death and or consideration, whichever is earlier,
my lord,
will prevail? Can you alter the legal position even if you amend it and you incorporate whatever you want to do?
my lord.
I can.
Well, but the defect will be there, my lord, people will go dismiss this petition, that defect it cannot be.
No, that I can always take care of, that we are not going, not on that defect.
And my lord, paragraph 14, my lord, people will say,
14.
14, my lord, just, I am going to that, my lord. This judgment, my lord, paragraph 14. Mr. M. Sodri, learned senior counsel, who is assisting the court as an amicus query, also bring to the notice of the judgment and order of the Patna High Court rendered so and so, where in paragraph 7 it has been held as under. What is in our mind that all cases of compassionate appointment to the post permissible under the existing circular should be considered together by one body. The circular confers right upon the dependent family members of government servant dying in harness to be considered for appointment to a suitable class 3, class 4 post. It does not make a distinction between different departments of offices. All government servants dying in harness stand on the same footing irrespective of where they are.
So, Gaurav, this proposition in our case, in the
Yes,
state of Assam,
My lord.
is by which OM?
Yes, this OM is passed on to 2015, my lord. That is,
2015 will not apply.
But yes, this OM was passed. So thereby I will some time may be allowed, my lord. I'm searching from judgment, my lord. Because of this OMM pass, entire other was considered along with that, my lord.
You see, you do whatever you want,
My lord. At
but
least, my
you
lord,
can't
because of
improve. You
the
can't
grade 4,
improve.
my lord. My lord, grade 4 and my
You
lord
just-
is working still today, my lord. So
You
my
just
lord,
can't improve because of the fact that there are three bench judgments of the Supreme Court of India.
my lord.
Can you alter the legal position?
I cannot, but
Yes.
this honorable court ordinance also passed. My lord. I'm not on that, my lord. At least my son, I maybe cure the defect and therefore your lordship pass on that.
No, but where is the defect?
Defect is my lord, respondent, my lord. Which I can see. Respondent, my lord, actually in secondary department, but I'm inadvertently look at the elementary.
So you want to include all the departments of the state?
Yes, my lord.
All the departments you want to include?
No, my lord, I am going to in secondary, my lord. Because of this post, my father was working under secondary department, my lord. So I may be allowed to that aspect, my lord. And if I'm not going to correct it, my lord, there's wrongly, my lord, going to, my lord. At least, my lord, 2 days, my lord, in the meantime, I'll file this case for correcting it, my lord. That also, therefore, you'll also dismiss it. Otherwise, your lordship, I withdraw and liberty may file case if, but that is also, my lord, your lordship permission.
Mr. N. Boral and counsel for the petitioner seeks to withdraw this petition and to file afresh, if so permitted by law. Matters is dismissed from the job with liberty as played for.
My lord, liberty means filing and face, my lord.
I've given you that liberty.
My lord, yes, yes, yes. Much.
All right. Yes, mentions.
Wait, please,
been
Your
made.
Lordship. My lord, in item number 32, I filed a IA for dispensing with my lord. And it may be called for.
Yeah, please, your lordship, I beg to mention item number 32, my lord. In this matter, personal appearance has been fixed, my lord.
Take it up
And
first.
we have filed one affidavit and an IA, so matter, that may be called for, my lord.
Okay.
I'll you apply.
If that reaches you, make a mention, we'll take it up
Fine.
out of turn.
May please, your
Yes.
lordship, lordship with regard to item number 5, your lordship, I am for the petitioner, your lordship.
Yes,
Lordship, the petitioner has expired, your lordship, so the matter
Oh.
is, there is no live issues is pending, lordship.
okay. All sides are duly represented. Upon instructions, Mr. DJ Das, learned counsel for the
Petitioner,
petitioner, submits that the petitioner has expired. And therefore, issue raised in this petition is no longer alive. So accordingly, matter since dismissed, having been rendered infructuous.
much obliged.
I'm appearing for my lord, initially 5, then after succession, respondent number 4, my.
I've stated all sides present. You want your name to be recorded?
My lord.
Time is left for the respondent number
Respondent number 4, present.
4. Mr.
As we announced.
S. Barua, standing counsel for Higher Education Department.
Lordship, I have respondent number 3. Respondent number 3.
Your name?
A Borpujari.
A.
Borpujari.
Bopujai, Miss A. Bopujai for respondent number 3. Okay.
May I please, lordship? Item number 11, lordship. The petitioner has already got released, lordship. May I close this
Item
one?
11.
My lord.
Okay, both sides are represented. Upon instructions, Mr. M. Khan, learned counsel for the petitioner, submits that the petitioner has got the desired relief and therefore he has instructions not to press this matter. According to this representation, and this was having not been pressed.
May it please, Your Lordship.
Yes,
Lordship, item number 6 and 7, my lord. My lord, petitioner has already retired, my lord. My lord, regarding in-charge headmaster issue, my lord. So, my lord, my learned friend also appeared in the correspondent, my lord.
okay, all sides are duly represented. Upon instructions, Mr. N. Boral, and counsel for the petitioner, submits that during the pendency of this petition, the petitioner is expired.
Both the petitioner and respondent, both are appeared.
The petitioner as well as the applicant have both expired, were both retired. And therefore, the issue is no longer alive. So accordingly, the writ petition as well as the interlocutory application.
Six and 7, my lord, both.
Also, 6 is also writ petition. In 6,
6
there
and
is a
7.
writ petition and IA. That and item 7, the writ petition, both stands dismissed, having been rendered infructuous.
Please, your lordship, I beg to mention item number 43. Please, the may be allowed to file implement petition.
Item
43.
46,
43.
3.
3.
Okay. Both sides are represented. Miss
S.A. Khalifa.
S.A. Khalifa and counsel for the petitioner is for adjournment to enable her to file impleading application. Prayer is allowed, matter stands adjourned. Let this petition be listed along with the interlocutory application, comma, if so filed for impleading. Okay,
Me, please, your lordship, I beg to mention item number 56 of the supplementary list, your lordship, and for the petitioner. With the consent of the other side, your lordship, I pray the matter be listed in a week. Item number 56 of the
56,
supplementary.
you want
list.
adjournment?
Yes, your lordship.
Okay, list after 2 weeks as paid for by learned counsel for the petitioner. You have taken consent of the other side?
Yes, we have your
Okay.
lordship.
With consent of the other side.
Much
Okay,
obliged.
Daily list item number 1 for admission.
In this matter, I am awaiting instructions because I was required to take instructions whether the amount released by the central government was received by the state government for madrasas to give to madrasas to the Urdu teachers, my lord. Now, this matter originally was being dealt with by the elementary education department, my lord, because the pre-senior madrasas were coming in then, the ME madrasas. And later on, with the merger of the madrasa education with the secondary education department, it has now gone to the secondary education department, but the secondary education department has not been able to trace out that particular court case file because so therefore we do not know the sanction numbers or anything. I had a discussion yesterday also. They are seeking for around a week's time, my lord, to trace out that writ petition from where we can find out whether the sanction had come or not. Earlier, it was being dealt with by the madrasa education. That critical desires. The other official records were transferred to the secondary education, but the court cases, my lord, in some of them we are finding it a bit difficult because the records are not.
Ask the officers to listen to a very old song. Abba. Money, money, money. With an amount of rupees 1497.11 lakh. If they can't trace out the money, definitely that song would be a wonderful experience. Okay. Both sides are duly represented. Mr. R. Mazumdar Leonard, standing also for the secondary education department, submits that despite effort by the authorities of the secondary education department, the concerned file could not be traced out. So it is submitted that earlier this issue was being dealt with by the Director of Madrasa, Assam, which has now been merged with the Directorate of Secondary Education, Assam. Next, the pair made the matter stand adjourned today. Give a fixed date after 10 days.
19/5. So.
Mr. Watson.
Yes.
My lord, petitioner is the daughter of my lord, Professor Melly. And our mother is my lord, Tora Bhuttai, my lord. During her childhood, my lord, the mother has been in love with someone, my lord. Thereafter, my lord, being a child, my lord. So I also went with her, my lord. Then later on came to know that my biological father is different one, my lord. So I passed my matriculation, my lord. Thereafter, I changed my father's name and my title, my lord. So I applied for the my lord, Seva, my lord, for sense of my title and my father's name, my lord. That has been not allowed, my lord. And the respondent has filed an affidavit, my lord. In the affidavit, my lord, they have not stated specifically, my lord, why it cannot be permissible, my lord.
No, because you see, in such cases, you'll have to get a declaration from the court. How can the authorities, relying on your statement, alter the name, surname, the father's particulars, mother's particulars? Because they can't, what you call, give a declaration as to the status, because under the Evidence Act, status is only by way of
My lord.
something which can be conferred by a court.
That I understand, my lord. Even past, my lord, I have my lord, looks to me come to the my lord, then page 25 in extra 9. That is a my lord gazette notification. My lord, the gazette notification, my lord, when I issued my sense of name and father's name in the gazette, will be assumed to be my lord. I have
Where is that gadget?
page 25 in extra 9, last my lord, second last page. This is a gazette notification, my lord. And the last page bottom is my lord gazette notification, my lord.
So only the name, this is your name.
my lord. My lord.
Without altering the particulars, you can just,
My lord, as per my lord, both provision, my lord. Such type of correction, my lord, only in case of clerical error, my lord, it can be done within 3 years from the date of commencement of the examination. And my lord, here, my lord, not only title, complete.
no,
name sense of the.
but this page 26 affidavit
Yes, my lord.
only changes the name.
No, my lord, and regarding father's name also complete sense, my lord.
No, no,
Rupeshwar
but in
Mili
this,
instead of Duleshwar Misang, my lord. Name, title,
you are
everything.
reading where?
My lord, in our affidavit, paragraph 9.
No, no. Mr. Sarania is showing us this gazette where the change of name has been entered.
Last question. Last.
But my lord, we have to go.
Show me your what do you call your document, your rules.
Yes, my lord. Clause 8, my lord. Correction of date of birth, name, title, etc. Subclause A, my lord.
Just tell me, I'm just thinking aloud.
Yes, ma'am.
There is a reputed politician from from Uttar Pradesh. After a long protracted battle, somebody won the case, getting a declaration that he is the son of that politician. You know the name, I'm not saying that name.
My lord, that one.
Correct. Now, what happens if I win a litigation and have the parentage altered? What happens to that status? I may not like my name, you know. I'll just tell you one more thing. You read in the net, you just open your net and check for a name, Jonathan Lee Riches. Just check up, you have your mobile. Jonathan Lee Riches. He is the world's largest litigant. His name appears in the Guinness Book of World Records. He started his career in litigation by first suing his mother, alleging that the mother did not look after him well, and he won the case. After that, anybody who crosses his line or road, he sued everyone.
Jonathan
And-
Lee Riches, my lord.
Yes, world's largest litigant.
And my lord, moreover, my lord,
So he also got a declaration that his mother did not treat him well. When he was a kid, he did not get a good, what you call, upbringing. That is his first litigation. World's largest litigant. So now, therefore, if somebody gets a declaration, and he says that his mother has eloped, biological father is different. Under that circumstance, if he wants to alter,
and my lord, on the last occasion, my lord, newly implemented party, my lord, I think the parents, my lord, they have implemented party respondent here, my lord. For
My
proper
lord, the
adjudication
rules,
of-
my lord, I am not aware of the law. Even then, my lord, the rules talk about the, my lord. Correction, my lord, not the sense, my lord. That is a difference, my lord.
no, but Mr. Roy, whatever he's saying, I find a reason now, having read this.
Yes, my lord.
You see, here it says, their rule says that if there is a mistake in recording the name, title, etc., in the office of the board,
Yes, my lord.
then they can do it subject to application being recommended by the
Head of the institution.
head of the institution. And there's also a time limit.
Yes, my lord.
It is required to be correct, my lord, incorrect one. My one is
Therefore,
sense,
therefore, you have to get a declaration, just like in the case of that UP politician.
my lord. There is nothing wrong in the records, my lord.
My lord,
I
the
am
party,
required to be correct. I want to sense. Correction is, they have the only correction, my lord. The rules is regarding correction. If any mistake within 3 years, 2 years, whatever it is. My one is not that one. My one, I want to
But then you
sense.
get a declaration from the civil court.
Yes, my.
My lord, when I have issued the gazette notification, my lord, that has been, my lord, not disputed by them, nor they are
No,
questioning, my
no, you
lord.
see, what you call this gazette
My lord,
is not a statutory publication
my-
made by you, because you are not an authority under whose authority name is entered in the gazette. It is only a change of name which is permissible to be entered in a gazette, and therefore gazette notification has been issued. But to change the name and other particulars,
my lord, in
it
essence,
relates to a creation of status.
my lord. Earlier, my lord,
No, I'm thinking aloud. This issue is live, therefore I'm giving that, what you call example. It may be inappropriate, but it is still an example. Now, one man has been declared as a foreigner. Correct. Now, X comes and says that, no, he is my biological son, and therefore now I buy an affidavit. He was never what you call a foreigner, but he was my biological son. I left him, and therefore by an affidavit, I give X wants to give a status to this child who was to a man now, who is declared to be a foreigner. I'm just thinking aloud.
my lord,
It's an example.
My
It's,
lord.
it's
otherwise,
just
my
an
lord,
example.
lordship right, but in my case, my lord, here is one Supreme Court judgment, my lord, one says, my lord, it's if I am not allowed to sense my title, it amounts to violation of Article 19, freedom of expression, my lord.
Show me that.
So that has been lucidly, my lord, full bench judgment, my lord. Then, my lord, under 226, court can, my lord.
Show me that.
That is 2021 7 SCC, they have group 4, my lord. Because first is whether this 226 under 226, my lord, it can be, mandamus can be issued or not. Thereafter, my lord, who are eligible, what is the difference between correction and change, my lord? My one is change. Change at any time, my lord, they can only, they have to that as administrative exigency, my lord. That's why they
Please
cannot
pass
do,
on
but
that judgment. Please pass on that judgment.
under concern also, my lord, I myself was the counsel, my lord, that is allowed by this honorable court in a single bench judgment, my lord. That is reported in.
If I remember this Jigya Yadav correctly,
my lord.
here, these directions were issued for correction of name to bring it in consonance with the school records.
My lord.
It's not a creation of a new record. Just give me 5 minutes, let me go through it.
My lord. The last portion is, my lord, I think 547, my lord, if I could remember
No.
correctly.
That observation that it has to be brought to the, what? It has to be allowed to make it in consonance with the school records, that part, I'm just trying to find out.
But here specifically distinguish correction and, my lord, sense is different. But this is a sense, my lord. It is my right after getting maturity, I have the right to sense.
No,
my
that is
lord.
okay, but let me look at the facts. Yes. Para 6. The appellant in this case, Ms. Jigya Yadav, has assailed the decision of the High Court of Delhi, wherein the High Court rejected the prayer for direction of to the board to carry out correction of a parent's name in the mark sheet issued by it. The appellant's case was that the name of her parents was incorrectly recorded as Hari Singh Yadav instead of Hari Singh, as recorded in the identity documents of father, and Mamta Yadav instead of Mamta, as recorded in the identity documents of the mother. Relying on bylaws so and so, we are omitting that. The court relied upon nursery application form, school admission form, and stream allotment form for class 11, filed by the parents of the applicant to conclude that the errors were not inadvertent, and they had consciously chosen and retained the names despite having opportunity to rectify before 10th standard.
Sorry, that was 6-7. 6-7 or 6-7. Seven, 8, 8. Oh, that was fine.
Yes. Mr. Sarnia,
My lord,
kindly note 4 paragraphs.
my lord.
Paragraph 170. One 83, 182. 183 and 193. Now, in this few paragraphs, I just roughly indicate and hand over you the book. There is, in 170, it says, there is no difficulty in correcting CBSE records to bring it in conformity with the school record. The difficulty arises when a statutory document is not consistent with the school record. As observed earlier, the version supported by the statutory documents could be reckoned for the purpose of correction in CBSE certificate to make it consistent with public documents. Then 183. Sorry, 182. 182 last part says, even if a constitutional court feels that the case at hand is deserving of an extraordinary remedy, it may do so using its wide powers under Article 226, but only upon specific appraisal of the facts of the case and after duly demonstrating the extraordinary character of the case. Despite holding that the prayers are impermissible under the bylaws, the courts in the present set of cases went on to issue directions to the board without having any regard to the factual circumstances of the case or to the nature of changes sought by the students by mechanically relying on the dictum of Subin Muhammad. Our concern is with the matter, the mechanical reliance has been placed upon the earlier decision for deciding cases which involved an altogether different set of changes. 183. Once a court of law notes that the applicable rules do not permit to grant a particular relief and it still goes on to grant the relief on sympathetic grounds, such decision can in no way be treated as precedents. We are constrained to note that the following of such decisions as precedents will be an utter disregard of the well-established principle of equity acts in personam, and thus courts cannot deploy equity in rem by replicating the same order, disregarding the personal characteristics of the case in hand. There can be no application of Subin Muhammad to a different set of facts. Then 193. Conclusions and directions to the CBSE. 193. The first is where the incumbent wants correction in the certificate issued by CBSE to be made consistent with the particulars mentioned in the school records, then it is permissible. Otherwise, I don't find this decision to help you.
My lord, that issue number 3 is relevant to me, my lord. Issue regarding probably from 97 paragraph. Actually, yesterday I find out that case. I have not gone through it, even then, my lord. Proposal in
You have
97
not gone
paragraph.
through it and you have basically.
I have gone, my lord.
Huh.
I have gone through it, but probably issue number, there is 4 issue has been framed by the Supreme Court. Whether 226 court can intervene or whether my lord correction and my lord sense is difference between correction and sense. Correction may be statutory rule, my lord. Because one date of birth cannot be 2 times, so there the correction will be required. Some spelling mistake is there, correction is required. That is within statutory period. In case of sense, my lord, the considering the facts and circumstances, my lord, and considering the Article 19, my lord, freedom of expression, my lord. So I, my lord, being a child till majority, I cannot say anything, my lord.
But here you see, even 194(2), it says that it is their discretion to exercise that power. Even 194(2), which you are relying on.
Because, my lord, because after getting maturity, coming to know, because I will be always I'll be being a son, I know my biological father, who is biological father. I will be known by a father who is not my father, my stepfather.
No, you see, we are not on those issues because that is not before us. But you see, what is the difficulty in a person getting a declaration from the court that he is the biological father is X and the biological mother is Y? You see, that declaration, social declaration, you are not getting. But you want a name to be changed in the record of the CBSE or the SEBA. How can that be permissible? X is the father of A.
my lord.
Now, A comes to court and says that, no, my father is not X. Please record my father's name to be B. You don't get a declaration from the court and you ask the SEBA to do it. Can they declare your character or status, relationship?
I will satisfy lordship, my lord. I will satisfy my lord. Not today, my lord. I may give you some time, my lord.
You read this 170, it makes very clear. Sorry, 170, 182, 183, 193. Because it says that the rules are to be regarded. The SEBA rules says otherwise.
Well,
The court cannot grant a relief which is contrary to act
My
and
lord.
rules.
My lord,
In one of the paragraphs here, initial paragraphs, it has been mentioned that the bylaws, they are not part of the act or rules or notifications. But still the authorities are bound by it.
my lord, under 13, Article 13, my lord.
No, Article 13 bylaws are not there.
Near, my lord, but
Article 13 doesn't
on the,
have reference
on the
to,
basis of delegated power, my lord.
it has. No, I still don't think bylaws are covered by Article 13. Let me read that. Yes, bylaws, bylaw is a law.
My lord,
Law includes any ordinance, order, bylaw, rules, regulation, notification, custom, usage, having territory in India, force of law.
the force of law. So if they have framed the rule, my lord, must be within the constitution, my lord. Frame of the constitution, because they are framing the rule only for correction, my lord, not for changing.
Okay,
My part is changing, my lord,
want
not
to-
correction. It is
you want
some
to argue the
wrongly
matter?
spelled,
you want to argue the matter today or you want some time?
not today, my lord.
Okay. So you made me read 190 paragraphs just for,
Last night also I took out this citation, my lord.
Hmm.
I have gone through it, but that seriousness is not there, my lord. There's a when
Okay.
choosing the paragraph, something, my lord.
but this
It's
is a
missing, man.
paragraph I read long back. I just remembered that this relates to corrections. Make it consistent with the school records. I suddenly remembered. I always don't remember that much.
My lord, but coordinate bench has allowed me another petition, my lord. That is the, which we, my lord.
But you have placed me before us a decision. No, we don't want to look at it right
My
now,
lord, my lord.
because if you are
And
taking an
it's not-
adjournment, if you are taking an adjournment, why
My
should
lord,
I
my lord.
read it?
In
Okay.
2014, it was allowed, my lord. Already he has changed his name also, my lord.
Hmm.
From the Silchar University, Assam.
Here some other day,
Yes.
both sides are duly represented. On the prayer made by Mr. M. Saranyar and counsel for the petition of the matter stands adjourned today. This after 2 weeks.
I love it.
You take back your regulations.
Yes, sir.
Yes, upgraded matter.
You know, the Learned Advocate General will be appearing the matter, my lord. He's on his legs in court number 1.
Okay,
Maybe after some time, my lord.
after some time.
My lord,
Okay.
yes. Donate maybe.
36.
36.
Okay, Mr. Sagia, your matter. After some time, let the Advocate General come.
My lord, I'm sorry, it is not on item. This is not the submission. I'm sorry. This is
Okay,
another item. Sorry.
okay. It's a contempt case. It's a contempt case. Yeah.
36 to borrow.
36 lordship in this conducting council be during it out of session lordship. Add to him will be made available lordship.
Okay, but this is,
By the concerned person, official person come lordship. But
okay,
add to lordship.
okay. What is that we wanted to know?
He's also inspector of school to do it.
Yes, your counsel says that it will be taken up at 2, so you'll have to wait for some time then. You can go out and come at 2 o'clock. Correct?
Article 32, learned AG would be appearing, my lord, after some time. He's on his case.
Item number 3. And 3. Okay, there is no representation from the petitioner. However, Mr. S. Bhuiyan, Leonard, standing counsel for the Higher Education Department is present for responding numbers 1 and 2. Next, the petitioner was unrepresented when the matter was earlier listed on 7/2/2020. So on the set date, this court had recorded the submission made by the learned counsel for the petitioners that the brief has been taken away by the petitioners. Full stop. Accordingly, matter was adjourned to enable the counsel for the petitioners to file an appropriate application. No such application has been found on record. Accordingly, it appears that the petitioners are not interested to pursue this petition. So according to this petition stands dismissed for non-prosecution.
Or
May please, lordship. Can you pass over for timing, lordship?
Yes,
Lordship, can you pass over for timing?
you have instructions?
I have the instruction because this is regarding the Mahatma Gandhi, Kostuba Gandhi's school, my lord. This
Yes.
is, for the girls. And there is a decision in the decision of the board, my lord, that no longer the male member will be taken up. And if there is a
It's
project
only-
approval board,
It's only a girls.
girls, so no member, the chokidar or the cook, no male member will be taken in the school. It is a policy decision
Okay,
and
after some
funded by
time-
the Senate.
After some time, let the council come. Okay.
My lord, in item number 8, we are reconstructing the file, my lord. I require some time.
2017 matter.
Yes, my lord, it is regarding some promotion of the grade 4 employees in the office of the inspector of school,
Whether Assam District Establishment
Which of the
Ministerial
rules
rules
will
or
apply?
the District Ministerial Service rules apply.
which will apply, my lord. No, I had
Okay,
I have to reconstruct the file.
okay, both sides are represented. Mr. R. Mazumdar, and standing counsel for the Secondary Education Department, prays for some time. Prays for an adjournment so as to enable him to reconstruct the file by then. Matter stands adjourned. This after 3 weeks. Give them a copy of the resolution. They can-
PDF should be.
9.
My lord, no affidavit has been filed yet.
So begin your argument.
My lord, the fact of the case is the petitioner is a chowkidar working since 1999 in the Torundam TC Pukon ME school.
Yes.
So my lord, the direction was issued by this honorable court at page 24 annexure 7 for selection on regular basis. Page 24, my lord, starts relevant pages.
Because that's under the post, what you call, Uma Devi.
My
You,
lord,
will have to apply when the vacancy is
Yes.
notified.
my contention is that, my lord, I have challenged the page 27 annexure A.
Page 27.
Annexure A. One person without any selection, he has been appointed there. So I had approached this page 27. As a challenge, I had a challenge this. So my lord, this is at page serial number 5. He is the respondent number 4.
Just a moment. Mr. Mazumdar,
My lord.
you go through it, we'll take it up at 2 o'clock. Because if he is challenging the appointment of at page 27. By
Well-
raising that he has not participated in the selection process. And then if you don't file any affidavit, I think we'll call the education department
My
here.
lord, what I find is that here in the cause
So
list,
both ways, we'll take it up at 2 o'clock.
cause list shows, my lord, a certain Mr. Chisti's name, he did not show his education, therefore I did not have the opportunity. Now she will take it up at 2.
We'll just try to, because
Yes.
it's. If that is the allegation and you don't file a response, we'll have to
I'll-
call the.
I will.
What is with the education department? In.
Right.
Item number 10. The petitioner is unrepresented. Mr. U Sharma done a standing question for the
Respondent number 1, 2, and 1, 2, 3, and 4, my lord.
respondent 1, 2, 3, and 4 is present. What is your stand in this case?
My lord, it is a matter regarding the revaluation of question paper, my lord.
Yes, yes.
And my lord, he was
Question paper, answer paper.
answer paper. my
Yes.
lord. Yes, my lord. And he was appeared in the examination in December 2015, my lord. And my lord, he was applied for evaluation in 27/1/2016. As per the rule of university, 1 month time is given for evaluation, but he has crossed that limit, my lord, that period, my lord. So his prayer was rejected.
Okay. Next para. the learned standing counsel for the respondent numbers 1 to 4 has referred to the
Whether my lord engaged
pleadings made in the
counsel.
writ petition to project that the petitioner had appeared in MA final examination.
Third semester.
No, is appeared in his third semester MA examination. And had also done some home assignments for the MA final examination in economics, which was held in February 2015 and August 2015 by the Institute of Distance and Open Learning within bracket IDOL bracket closed at Guwahati University campus. And that the prayer of the petitioner is to direct re-examination, public re-evaluation of the same. Just referring to the affidavit in opposition, it has been submitted that the petitioner had appeared in his MA examination in economics in the year 2014, and subsequently he appeared in the third semester examination in the year 2015. And the results of such examination was declared in the month of December 2015.
7/12/2015.
7/12, okay,
Yes, ma'am.
2015. So it is submitted that as per the Guwahati University rules, comma, a candidate is allowed to apply for re-evaluation or re-examination within 1 month from the date of declaration of result. Full stop. It is submitted that while applying for the re-evaluation,
On
Come on.
27/1/2016, my lord.
20,
27/1/2016.
okay, it is submitted that the application for evaluation was made on
27/1/2016.
27/1/2016 for the result which was declared on 7/12/2015,
Yes.
and accordingly the prayer for re-evaluation could not be considered. First of all, in this regard, reliance is placed on the university notification dated 7/1/2009. Next one, be that as it may, it appears from the record that the petitioner was absent on call when the matter was previously listed on 19/12/2017, as well as on 18/11/2020. So today is the third date when the petitioner remains unrepresented. Accordingly, court is of the view that the petitioner is not interested to pursue this writ petition, and accordingly this writ petition stands dismissed for non-prosecution.
Well,
May I please, your lord?
Yes, Mr. Prakash, sir.
This matter relates to my lord appointment on compassionate ground. This is a
Yes.
contested case. Initially, my lord, we filed a writ petition. Then, my lord, court was of the view that since the appointment of private respondent number 7, 8, and 9 are challenged, therefore you withdraw the writ petition with the liberty to file. Accordingly, we filed the writ petition, my lord, impeding them as party respondent. Now, my lord, matter was heard on, my lord, on several occasions. And at the last occasion, my lord, the government filed an affidavit saying that, my lord, they referred the matter to SLC, and SLC, my lord, rejected our contention, our claim. The recommendation of the DLC was rejected by SLC on the ground that, my lord, there is a lack of documents. But our whole case is that, my lord, my father died in 2012. I immediately thereafter, my lord, within the statutory period, I applied for. That was duly recommended and matter was placed before DLC, and I was, my lord, recommended against one of the posts which occurred during that period. There is 1112 to 31/8/2012. And, my lord, we have annexed all this thing. That one, my case was referred to, my lord, sent to SLC. SLC says there is no vacancy. This is the stand of the SLC. Now they are saying lack of documents. On the other hand, the private restaurant number 6, 7, and 8, as your lordship knows, my lord, if the application is barred by limitation, if it is a belated application, the question doesn't have us to consider their case. And accordingly, their case was earlier rejected by TLC. Subsequently, my lord, when considering my case, TLC, my lord, made recommendation in their favor. And, my lord, then matter was placed before the SLC. SLC considered and appointed them. Now the question arises, my lord, once their application rejected, is there any scope to, my lord, restore the position and, my lord, accept their application to be within the period of limitation? And on the other hand, my lord, when the entire matter is pending before the court and their action is under challenge, what is the question for the government to refer the matter to SLC and to reconsider the matter without any leave, without any intimation to court? And now they are saying, my lord, in their affidavit, lack of documents. At paragraph 2 of their affidavit,
Affidavit of whom? Who's the affidavit?
my lord, kindly have a look.
Who's the affidavit?
Affidavit
By respondent number 2.
by respondent number 2. Stated, it was filed on 11 November 2022. At para 2. However, the application of the petitioner for
That's all. Yes,
my lord, kindly peruse para 2 of their affidavit. There is serial page number, my lord, 101.
yes.
Last line of para 2. Petitioner application for of the petitioner for completion appointment was rejected due to lack of documents.
Yes,
What is the lack of documents, my lord? On the matter is subject, as earlier you said, there is no vacancy. And my case was recommended against the, my lord, existing vacancy.
where is the relevant entry in the SLC minutes, minutes?
Yes, yes.
108, page number 108.
10,
Serial number 11.
no, you'll have to rectify it, it's not 108. It's been. Vikas is
SLC
186,
recommendation.
now it is 186.
2004.
Serial number 11, Pratap
11,
Rabha. Rejected due to lack of documents. Then you have the record with you, what documents are lacking?
My lord, I
SLC,
don't have the
SLC.
record. My lord, this affidavit is
14,
filed by Education Department, School Education.
Okay,
Vijay Ashok.
yes,
Vijay Ashok. Secretary.
Department of School Education,
Well, this.
She was then holding the post, my lord.
মানে এইটো 2012 ৰিকমেণ্ড কৰিছিলে DLC এবাৰ SLC ৰিজেক্ট কৰিলে আৰু সেকেন্ড টাইম ৰিজেক্ট কৰিছে লেক অফ ডকুমেন্ট ৰেকৰ্ডটো আউট অফ
You have to directly to produce the records then. What is the lack of document? And yes, Mr. Kaim, what is your stand? You are for the private respondents?
Yes, madam.
What is your stand?
But I have filed an affidavit, my lord, and my Islamic paragraph, my lord, is.
Please come to the arguing table. I am not hearing you properly.
My Eastern Milota at page Milota 77, paragraph 5 million.
But what about your earlier rejection?
Yes, my lord, after rejection, my lord, they filed application before the government. The government again, my lord, directed the deputy commissioner to place the matter before the DLC. DLC was, my lord, considered. Then, my lord, the matter was, my lord, recommended to the SLC. SLC, my lord, selected us, and my lord, we have been appointed in, my lord, 2015. Because, my lord, resolution number 7 and 8 was, my lord, earlier selected in the meeting dated 27/9/2004. But thereafter, my lord, when the matter was pending before the government, the judgment of the my lord Sudhir Das was came out. Then it was, my lord, placed, but it was rejected on the ground that it spent its force. So we approached the government. The government directed the deputy commissioner to place.
Where is the document?
Yes, my lord. A lordship may kindly turn to page, my lord, 9. Page 83 million, running page.
Yes,
Chapter 1.
yes.
Then Millard page 84. The name of the resolution was 7 and 8 at serial number 7, Zakir Hussain Khan.
Serial number?
7, page Millard 84 million.
Yes, Kalpana
given-
Rabha.
Yes, no Millard. It is Millard page Millard in my affidavit. Page 83.
Yes, internal page 2.
Millard.
Yes, serial number?
Millard serial number Millard 7. Page 84 and internal page 9 million. Then the original page Millard
No,
86.
what is your name?
My name is Zakir Hussain Khan and Millard Abdul Salam. 7 and 8 million.
Zakir Hussain.
Zakir Hussain Khan. It was the meeting Millard dated 27/9/2004.
Zakir Hussain comes serial number?
7.
7 is at page 83.
Page 84 Millard. 83 million. Maybe Millard.
You see, this annexure starts at page 82, correct?
Maybe Millard 82.
My minutes of meeting of the DLC
Yes, Millard.
of
27.
31/8/2020, 2012.
No, Millard. In my affidavit, Millard.
You told us page 76. 76 is affidavit in opposition by respondent number 4.
No, Millard.
No, rectify your serial numbers, it's different.
Since my lord, the repetition is my lord ending with 75, so my lord, I have started my lord 76.
No, it's okay, because in between, there are other affidavits. Page 8 is the letter of 4/11/2004.
Yes, yes, my lord.
Yes, okay.
Then my lord, the minutes of the
7 and
meeting dated
11.
27/9/2004.
Yes,
Then my lord, next page, my lord, the name of the resolution was 7 and 8, my lord, at serial number 7 and 11. Is that right copy, my lord? And the original page at page my lord, 86.
okay, this is your rejection.
No, my lord,
Earlier.
it was selection,
This was selection.
my lord. Before my lord, Uchitendra Das case.
And where is the direction by the government? To
That is
consolidate
my
the
lord,
records?
an except 2 my lord.
Page,
Page my lord, in my lord, it is my lord, in the page 12,
page 12.
my lord. Second last paragraph, my lord, consider the period of the prisoner, the matter was reviewed that the department may allow the period and the matter may be remanded back to the district level committee.
Okay, I
consideration.
get it, I get it.
Then my lord, however, their case was rejected again. That is my lord, 2011, then again it was placed and it was considered 1 million in internal page, 14.
Yes,
Letter and page 17, the name of internal page 17, serial number 2, Zakir Khan,
they were approved.
Miller,
Their cases were approved
approved by the DLC Miller.
by the DLC.
Then in the next page, serial number 1, the resolution number 9 was recommended by the DLC. In the meeting dated 5/3/2013.
Okay. But Mr. Fukan, you are appearing for the education department, you have to produce the records then.
I'll get my instruction and also produce it.
No, instruction will not do because your affidavit is there.
I know.
Rejected because of wants of documents.
I know.
What are the documents?
The records. Sir. The next day.
But Mr. A.K. Purkar, sir, and Council for the Petitioner. Mr. A. Fukan, Leonard, standing counsel for the Elementary Education Department, and Mr. G. Leonard, Government Advocate appearing for the respondent number 4. SLC also, I think,
Yes, ma'am.
maybe for 2 respondents.
2 and 4. I
2
am
and
for
4.
1 and 3.
Mr. Fukan for 1 and 3. Government Advocate for 2 and 4. And Mr. D. Kayum, Leonard. No, 2, 4, 5 and 6 also.
No, ma'am.
No, 1, 1,
and
3,
6.
1, 3, 5 and
6.
6. Mr. D. Kayum, Leonard. Advocate appearing for respondent number 7, 8 and 9. That's right. The learned counsel for the petitioner has referred to the affidavit in opposition filed on behalf of respondent number 2 by Dr. Vijaya Chaudhary, Vijoya Chaudhary, Secretary, Department of School Education. Filed on 14/11/2022 by so and so. Wherein the reason assigned for the rejection of candidature of the petitioner for appointment on compassionate ground is reflected as inverted commas, rejected due to lack of documents. Yes, sir.
We have
The,
also filed reply.
the said statement is supported by the minutes of the state level committee held on 26/8/2022. In respect of district of Goalpara against the candidature of the petitioner, Sri Pratap Rabha, the said remarks has been entered. Next, accordingly, the longest standing counsel for the Elementary Education Department shall produce the records relevant for the petitioner, i.e. Pratap Rabha, serial number 11 of District Goalpara, referable to minutes of the SLC held on 26/8/2022. Next, the standing counsel for the Elementary Education Department shall send a downloaded copy of this order to the competent authority to ensure that the records are produced on the next date of listing. Next, this one, give 4 weeks time. Give a fixed date.
29/5.
Obliged.
Please, your lordship.
Yes,
Lordship, in this matter, certain instructions are required to be taken. The matter has perhaps become infructuous.
that's what I was thinking. Okay. Both sides are represented on the pair made by Mr.
S. Rava on behalf of R. Chakravarti.
S. Ravar and counsel for the petitioner, matter stands adjourned to enable him to obtain instructions as to whether the issue raised in this red presence is alive. Is alive. Matter stands adjourned today. List after
4 weeks time, my lord.
4 weeks.
Lordship. We are UGC respondent number 5. We have not received extra copy.
You will never receive it unless you demand. You take his phone number and pester him till he gives you the copy. Good time to pester is between 1 o'clock and 3 o'clock in the night. Then he will remember and give it to you. Correct? You know how to pester? No, you don't know how to pester. Then we'll have to send you somewhere where you can learn that art. Pestering you don't know, then you'll have to learn that art. One cannot be a good lawyer without knowing the art of pestering. Okay. Ask someone and then do that to him. Learn that art. Right.
Obliged.
Item number 4.
Please, your lordship. My lord, if any affidavit, my lord, is filed, then my lord, there's no affidavit has been filed today.
He's not filing an affidavit, but in a girls' school, he says that the male,
Yes,
what you call, cooks are not allowed.
Yes, madam.
During the
But,
2016, 2017 project approval board that annually sits in Delhi, they have policy decision has been taken. No female person will be taken.
No, but
No male person will be taken.
you see, he's holding a brief. Give him that information so that he can tell the what you call the his clients. Correct? Because we can't, he'll be at a disadvantage if I dispose of the replacement like that. He has no notice.
Lordship,
Correct?
Lordship,
You just reverse the roles. Once you stand here, then you will understand.
Lordship,
If your reputation is being dismissed on technical grounds without being put to notice.
If Lordship allow me 10 days, I will file an affidavit.
Either if you are giving the instructions,
Lordship.
both sides are duly represented. Mr. has brought up and standing counsel for the
SSA.
SSA submits that as per the scheme of appointment for Kastuba Gandhi Balika Vidyalaya, as the school is for female students. The as a policy decision, the only female cooks are being appointed. Next, accordingly, the learned standing counsel for the SSA shall either file an affidavit or provide a copy of the concerned notification to the learned counsel for the petitioner.
Better file a affidavit, it might be on record.
I said both things. Next one. The same may be done at least 2 days prior to the next date of listing. List after 3 weeks, give us 6 days. 17.5. Fourteen.
Lordship, my senior is 11, court number 6, Lordship, kindly matter be adjourned for the time being.
Okay. After some time. 15. You have filed your affidavit, no?
Lordship, we have filed an affidavit.
Okay.
We filed an affidavit, Lordship, on 7th of September 17 itself. Regarding the appointment in the Kachar district.
I think the matter of this nature has already been decided by this court.
Some matters I think fixed tomorrow also. Regarding that.
No, those don't relate to that, what you call this, Assamese and Bengali. I think this relates to that language issue.
So here, my lord, the district is Kachar. Here we have stated categorically, my lord, in paragraph number 5. And
I think this issue has been decided. You see, if I remember it correctly, this advertisement,
my lord,
it only says that you are required to have a knowledge of the language of instruction. Am I right?
yes, sir.
So where is that advertisement?
Advertisement, my lord, is at page. Starts at page
Page 19.
19, my lord. Annex 1, 19.
Yes. Now, a candidate must possess, page 21, the ability to read, write, and speak in the medium of instruction pertaining to the district in which the candidate wishes to apply.
Right.
So you see, by default, I may know any other Indian language, Let us say for an example, a language which I don't know. Say for example, Kannada, I don't know. But if I learn that medium, I can speak and write and read in that language. How can I be debarred from by virtue of this clause 2? For example, I can speak and read in Bengali. My fluency is gone because I'm not used to speaking Bengali, but I can. If I speak with one of your in Bengali for one day, I think I'll be able to catch up.
But my lord, how do we verify whether they know the teachers who get
No,
qualified?
it is your advertisement. You must know how you can verify before
Because,
issuing an advertisement.
Get,
Because anybody knowing Assamese can very well speak Bengali. It hardly matters.
The petitioner also not here.
No, they may not be there, but the court is there for them. But this is an issue we'll have to answer. You can't avoid this just because the petitioner is not there.
Well, if the person doesn't know proper the language of that particular district properly, then again, the communication.
You don't say that. You see, for an education department,
With my limited.
no. You see, you have had experience as a student, right from school, college, university. Correct? You had experience. Have you not found us in your career a teacher in English who can't speak fluent English?
No.
You have not found.
No, we found.
You found. So you see, the ability to teach is one part. I may be spelling or uttering sentences wrongly, but if I can still teach, those teachers have given their effort. They have taught you, and then now you are here, speaking fluent English. So it's not the ability for the teacher himself to speak, but to deliver the goods. When I was a student, I took a tuition from a particular teacher. I am not naming him. When we went to his home, we can't understand anything. And the teacher says, why you're wasting your time and money coming to my home? You go to the class, I can teach you well there. And in the class, we were what do you call, overwhelmed with the manner in which he was teaching us. No second questions were asked by any of the students in accountancy, where everything is all arithmetic. No questions by anyone. So ability to speak, understand. You don't put a qualification, you see. Otherwise, if the government had an intention, he would have given a qualification that in the medium language, he should be MA at least.
That is there to some extent when they in the TET examination, they have to select a language in which they are proficient to impart education. It is a part of the TET examination, and it is that language because one language is compulsory, English is compulsory, and one language they have to choose. That this is the language in which I am comfortable in imparting the education. Now, if that language was not chosen by these petitioners, they have not taken their proficiency test. We do not have other means of putting in any other proficiency test to see whether they would be able to, persons from the Barak Valley or persons from the Brahmaputra Valley, when we had the practical experience that they could not impart proper education to the students because of the language barrier. Because here, Lordship will find that the languages used are either one is called Mar, then HMR Mar and Bengali, and other languages. Now, persons from
Mr. Was just a small what you call pipette. it may be wholly inappropriate, but still it's just a story. In the trial court bar, there are two lawyers. The other is a junior of the first one. And when they start speaking in Assamese, even the best of the persons having knowledge of Assamese will say that please be in English because I can't understand your Assamese. When he speaks Assamese, he will use the administrative glossary.
Yes.
And he will not use an what you call an English equivalent. He will not say deputy commissioner. And I've seen people in awkward position, even the judicial officers, they won't be able to follow those two lawyers when they speak in Assamese. So when people instigate, there are few witnesses who instigate lawyers saying that, oh, you can't ask in Assamese. Because well, okay, let me ask you in Assamese. And then people start crying. I'm not on that. But you see the proficiency test,
Yes.
as I said, for a teacher, it is his ability to deliver. The
So therefore,
proficiency
that
test.
test he has already taken, whether he's, because madam, the TET examination, if Lordship would find the format given. So there's no whether it is given here or not, but the produce assessment. Technology পরীক্ষা দিয়েছে আমার এখানে
No, you see, Mr. Mazumdar,
madam,
what you are saying
yes,
is a proficiency test in TET.
that
Or you do it on the, also under the, what you call, recruitment done by your department.
no, that TET examination is madam, for
So
people
this
to
proficiency
teach it.
language is a test conducted for, by whom?
The TET examination is conducted by the.
No, proficiency test in the language
Yes.
where education is to be imparted.
Is
This
the-
test is conducted by
Well,
whom?
we go by the language, either by the language which he has chosen as his preferred language of instruction in the TET examination, or in case of some Assamese medium schools, well, there was a certificate of Assamese being given by the Assam Sahitya Sabha. So that part was taken into consideration while the instruction, because the
maybe
medium of
we'll-
instruction
no,
was
no.
important.
Maybe, but.
At para 8 of my affidavit, my
No, no.
lordship will find
Come to page 23 of the red petition.
23 years. My lord.
This is TET roll number, date of birth,
Yes, name of the
from
candidate.
name of the
address.
candidate, mobile number, language,
Yes.
one, gender, caste, physically
Yes.
handicapped, qualification, year of passing, marks obtained, total marks percentage,
Yes.
SSLC, graduate TET mark, mark in diploma in B.Ed, D.Ed, NCC sports culture. Now, where is this proficiency in language?
My lord, language 1. Language 1 is the language he had opted for in the TET examination. That is where it comes in. That is how the medium is chosen, because here we are dealing with elementary school children who even the NCT had to lay down the norms as to how
No,
a
no,
teacher
no.
is to be.
It's not acceptable. You see, I'll show you why. You come to clause 2 at page 21.
21 years.
A candidate must possess the ability to read, write, and speak in medium. It doesn't say about the qualification which I had in my metric. Maybe I had
I'm-
English,
we are
English 1, English 2, 3,
We are not asking for that, my lord.
Hindi.
This language 1 at page 23 is the language in which he had preferred if in the TET examinations, which is mandatory, as
That's what
his
I'm
preferred
asking.
language of.
No, no, you see, that's what I'm asking. You see, I have more proficiency in English.
Yes.
I opt for English as the medium of examination.
No, madam, English is compulsory. The regional language is taken up as this language
But
1.
this column is not for regional language. You say language 1.
I know that Lordship will give me some time that the manner in which the TET is held, my lord. This chosen language, what language he had taken as his medium of as a test, my lord, to see whether he's proficient in imparting education in that language or not, is also seen in the TET examinations, my lord. That is a part of it. Whether he can actually teach in that particular medium. Because here, my lord, the schools, our schools, these schools are not schools where, my lord, any and all languages are used to impart education. Locality schools where a particular medium has to be adhered to impart the education, otherwise, my lord, the children, they lag behind. Or
No,
it
but
is
you see, language one will always be the language which is the preferred language for me.
my
If
lord,
I am the applicant,
because at that point of time, the TET paper, the TET paper, my lord, which he appears in, it is his choice to say that this is my preferred language to impart education. And that TET paper, it evaluates whether he's proficient enough in that medium or not. He has to pass that paper also. In case I say tomorrow, as a following from Lordship, my lord, if Kannada is my preferred language, I take the TET examination, I fail. I fail in the TET. I'm not allowed to even apply for this post. But if I take up Assamese as my paper, which may not have been my paper in the matriculation examination or in the higher secondary, but I prefer Assamese as one of the papers, I pass. I will get a post in I can apply for a post in an Assamese medium school.
okay.
But that will not allow me to apply for a Hindi medium school or for a Manipuri medium school.
But the statement which you are making, where it is documented,
The test, the TET pro forma will show the manner in which the TET is held.
you can,
How that language is taken as a preference. Why I am given a choice of preference, madam.
they can, you can show it to us.
My lord, that I'll just have to take a printout or something and I'll show you. It's available in the net, the TET, how the examination is held, the TET things there in the net.
Take it up in the second half, then,
I'll bring that on to Lordship's notice, madam.
okay.
That is why this medium has been made specific.
So this
Otherwise,
language,
otherwise we want better teachers. Persons who score more marks, we want them in. There's no
you're trying to say that the pro forma application, the language one is relatable to a language in which one wants to impart.
language. He takes a test in that.
Okay, so this
English being a compulsory language,
it is irrespective of the medium of education which one would have.
one would
had.
have. Otherwise, my lord, if one wants to be a Hindi teacher, then he may have a certificate in Hindi. Even if I don't take up the one language in a particular in the TET, if I do not take up Assamese, if I take up Bengali, but I have a certificate in Assamese that I'm comfortable with Assamese, even that helps him to get the job. Then also we do not stop him. Is what I have found otherwise, because I remember there was one case where we required a certificate of Assamese from the Assam Sahitya Sabha, but because of the COVID, they could not undergo the course. Matter was delayed till a time where they could undergo the course and come back and apply. So we need some evidence that the person we are taking in
Has
is
proficiency in the language he
Yes,
wants to
otherwise
impart
it
education.
cannot be simply our evaluation. And what has fallen from Lordship, that other case where Lordship has said is that it may have been decided. Even I recollect some matter like that.
Because when
2
I
years
was taking
past.
up this education bench last, I remember
Yes.
having heard this matter.
One interesting question had come up, my lord, when he's supposed to teach Hindi, why does he require proficiency in Assamese? Hindi will be taught in Hindi. Hindi cannot be taught in Assamese. So that question had also come up. I forgot what was I do not remember whether it has been disposed of or still pending, but those issues had come up.
This issue arose when I was a student. There was a big commission because of this language issue. Particular classmate of mine had some political links and he came to the college saying that the education must be imparted in the language of his preference. And the English teacher just refused to do it because he said that I can't teach English in Assamese.
Yes.
It happened in my classroom. And then we had to, when everything failed, the students came together to inform the boys and their parents and the political persons that why English must be taught in English.
That is what the language has to be taught in the language itself. One cannot use another language to teach one language.
So
here the subject matter is
when you say that, I have a recollection, that is why because language must be taught in that language alone.
The TET format, my lord, I'll try to show. Whether we are wrong in
And that
asking.
you will understand. Once you read this, there's a grammar by ELTS, English language. ELTS, I forgot, English language. There's a, what you call, organization, English language test or something, I forgot. They have a grammar of English grammar for English students, and then there's a English grammar for foreign students.
Sure. Earlier, there was a test also, we called it TOEFL. Test of English as a
was
foreign
different-
language.
Different thing. And I had an occasion to ask the people of that society,
My lord.
what do you mean by this distinction? Why English for an English student and English for a foreign student? Then he explained to me, so far as I am concerned, my mother tongue being Hindi, for me, English is a foreign language. So that's an English which is acclimatized with the Indian tone so that we can understand English better. But if the grammar which is being taught for a what you call for a student who's otherwise mother tongue is English, theirs would be different. Then I understood. You see, this language everywhere is spoken differently. Maybe a man from Bihar would speak Hindi differently. From man from South will have a different tone for a Hindi. So then I understood this.
Somewhere, my
Having a
lord,
grammar for a foreign student.
somewhere I had found, my lord, that this language Sanskrit spoken at any part of the India or any part of the world, 90% of the pronunciation remains the same because that pronunciation, it almost remains the same wherever it is taken up. Sanskrit is unique in that.
I don't know. This is a language I don't know.
That Sanskrit
I'll
is
take a
a
break and come back.
my lord, yes. Obliged.
Advocate General, you have to argue in the matter.
Yes.
We'll take it up after that. I'll take a break and come back.
14. WPC 3286, against which the contempt order is now resulting.
No, you see. Please come back to page 37.
Lordship,
Now you are trying to say that this was a direction issued,
yes,
that they would have to give some documents and then you would embark on a verification. And if on verification, their appointments are found to be valid,
Lordship,
then you will proceed.
definitely.
Correct. Now, if that exercise was not done by the petitioner, that what you call the
They have not complied this
they have
order.
not complied with you call
With
the
the
documents, the documents. Now, still, was there a bar again for the authorities to reject the candidates?
We rejected it. We rejected it. And therefore, this order of 17 to 2007, that is the subject matter of the contempt petition.
Where is that order?
Page, in the contempt petition, page 12.
Page 12.
Paragraph 12 onwards.
Just one.
The order from 7/27, 2014 order to police.
Terminated. 752 minus 35. Terminated. No, 35 is out. 770 is terminated. 35 is not terminated.
So, Sekar, please give me the page again.
Lordship, please 12.
Page 12. 12 is the High Court order. of
High Court
17
order, yes, Lord.
That refers to, para 12 refers to our order list.
Paragraph 12, impugned orders 27/3/2000. That order I am not having right at this moment. It's a part of the writ petition, which was put to challenge. In that order, we have said that they belong to the category of 752 terminated teachers. Appointment to 9.
But if I have understood this correctly, para 17, at page 16,
Yes,
it says in the instant case, the petitioners were appointed in the year 1989. They have rendered service for 28 years now. As a matter of fact, they were paid salary up to July 2007. For a period of 18 years, continuation service by petition is not disputed.
Hmm.
And as per the admitted stand of the respondents, no termination order has been issued to the petitioners.
in such circumstances, withholding of the salary of the petitioner would
No,
not be justified.
No, I'm just stopping here to emphasis on your submission that there was already a termination and they were a part of the terminated teachers. That is what you are saying.
Their whole contention originally was that they were appointed in terms of an honorable High Court's order.
Yes, okay.
Appointment order was issued. That they could not produce till date. The order which they are referring of 1989 was that there are certain teachers who were not having, there are certain candidates who are not having those trainings. They were allowed to participate in the recruitment process. That was not an order for giving them appointment, on the basis of which the director might have issued a order of appointment. So we are trying to find out that document, which they are supposed to give us. In fact, a lot of persons were arrested, many things happened thereafter.
Okay.
এটা আমি কি করবো বলে এটা? If Lordship is pleased to look at the order of 19/5/2022 in the same contempt proceedings, Lordship, the elaboration of the
Just
complete facts were
No,
detailed here.
just a moment.
19/5.
Page.
It is in the court's record, Lordship. Internal page
Court's order is
19/5.
Oh, order of the court.
Yes.
Acha, okay. Okay, order dated
19/5.
19/5/22.
Lordship.
22.
You want 2012 enquiry to participate করেছে করেছে ওনার রেকর্ড নাই আছে
Because they receive salary up to students.
Yes, 19/5/22.
Yes.
In order to put it, say, history to control.
May I read it, Lordship? The facts leading to WPC, I'm reading from paragraph 3, Lordship.
Yes,
The facts leading to the WPC 3286 of 2014 has a checkered history to the extent that the petitioners were participating in the selection process sometime in the year 1987. An issue had arisen as to whether the petitioners, being untrained teachers, can also participate in the selection process. The said issue raised by the petitioner resulted in civil rule of 212/87, which was given a consideration by the judgment and order dated 25/4/1988. In paragraph 3 of the said judgment, it has been provided that on an agreement of all parties, percentage-wise division mentioned in the letter before the court has to be read along with Rule 3, Sub-Rule 3 of the Assam Elementary Education Rules 1977, and that
okay,
preference.
just a moment. Where is this order of this civil rule 212/87? Where is this?
That is not here in the.
That is not
That
here.
is not here. Okay, okay, okay.
of the Assam Elementary Education to 1977, and that preference should be given to candidates trained in senior basic, normal and junior basic training courses. It was further provided that in dealing with the matter, the respondent authorities to also take note to Rule 12 of the said rules, which provides for some relaxation, and further that even untrained teachers were not altogether debarred from being appointed. The judgment and order required that the cases of the petitioners should be considered in the light of what was observed in the said judgment. Non-compliance led to civil original petition contempt 105 of 88, wherein an order dated 29/8/1989 was passed, requiring the authorities to comply with the earlier judgment of 25/4/1988, meaning thereby to consider the claim of the petitioners that even untrained teachers would not be debarred from getting appointment, and further that the authorities may look into the requirement of relaxing some provisions of the law. There was no materials to show that the petitioners were accordingly considered, and that they had participated in some legitimate selection process, and pursuant to which they were selected and thereafter appointed. This may be marked, Lordship. In the circumstance, and communication dated 3/10/1989 was made by the Deputy Secretary of the Government of Assam in Education Department, requiring the Director of Elementary Education Assam to comply with the judgment of 25/4/1988, which had already been referred herein above. After that stage, there appears to be an order of appointment dated 16/12/1989 passed by the Deputy Inspector of Schools, Dhemaji, whereby
You can take your seat. You can sit down for some time.
passed by the Deputy Inspector of Schools, Dhemaji, whereby one of the petitioners was appointed as assistant teachers in number 2 Laktokia Primary School in the pay scale of so and so, against a vacant post which had fallen vacant on the demise of earlier teacher. Similar orders in respect of other petitioners were also available. The said orders of appointments is the basis of claiming a right by the petitioners to receive their salary and allowances. It is submitted that earlier order dated 29/8/1989 is an interim order, and the contempt petition civil so and so was given a final consideration by the order dated 18/6/1990, whereby the order of appointment indicated above was taken note of and the petitioners were directed to be paid their salaries. It appears that the petitioners had received their salaries up to August 2007, and thereafter on non-payment of salaries, the petitioners has instituted 5085/2008. This is a division bench matter, Lordship, wherein an order was passed that in view of the clear and categorical stand of the official respondents that the services of the petitioners were not terminated, a direction was issued that the petitioner would provide before the Director of Elementary Education Assam certified copies of the orders of the court, if any, pursuant to which they claim to have been appointed to the post. It is said that the said exercise required to have undertaken as per the order of 5085/2008 had not been undertaken, inasmuch as the petitioners could not produce the relevant documents which would support their claim of appointment. In the circumstances, the claim of the petitioners stood rejected. Accordingly, WPC 3286 of 2014 was instituted by the petitioners, which was given final consideration by the order of 17/2017. In the order dated 17/2017, in paragraph 17 thereof, the court came to the conclusion that the petitioners were appointed in the year 1989, and they have been rendering their services for more than 28 years, and they were paid salary up to July 2007. That is for a period of 18 years, and further the continuance in service by the petitioner is not disputed, and it was the admitted stand of the respondents that no termination order was issued by to the petitioners. In the circumstances, there was a direction to release the arrears salary to the petitioner from August 2007 onwards, alleging non-compliance of which the present contempt petition is instituted. R. Mujumdar, learned counsel for the Elementary Education Department, raised an issue that although in paragraph 17, a conclusion was arrived that the petitioners were appointed in 1989 and their continuance in service is not disputed, but in view of the earlier order of the court, which had been referred above, the legitimacy of entry into service of the petitioner still remains an open question, and any allegations of willful and deliberate violations of the order of 17/2017 in WPC so and so would have to be looked into from that perspective. If the legitimacy of the appointment of the petitioner is yet to be established, it is the contention of Mr. R. Mujumdar that mere presence of the petitioner in the institute may not, under the law, can be construed as to be continuance in service, in as much as the very concept of service itself presupposes an existence of a legitimate entry into service so as to enable a person to claim that the person is in service. R. Mujumdar Learned Council state that in the meantime, the officials of Education Department have changed, therefore the presence of the present incumbents may also be necessary. If it is so advised, the present incumbents be at liberty to appear before this court to render their assistance. Now, paragraph 9. It has been further brought to the notice of the court that the order dated 25/8/1982 of the Deputy Inspector of Schools Dhemaji, which is available in Annexure 8 series, provides that pursuant to a letter dated 7/7/1992 of the Director of Elementary Education Assam, the services of the petitioners were regularized on the strength of the judgment of the court order dated 18/6/1990. The respondents to produce the letter dated 7/7/1992 of the Director of Elementary Education, if available, as well as the judgment of the court dated 18/6/1990, which is alleged to have been acted upon. Now, this is one side of the story. There is another part which my learned friend could not place it before the Honorable Court. In 2019, the division bench was considered for taking up the education bench. There, this kind of litigations were in abundance. Finally, the division bench directed that we should hold an inquiry of all these kind of persons who are not receiving salaries, whose appointment is doubtful. Pursuant to that Honorable Division Bench order, Lordship, the state has instituted 4 screening committees and a full-fledged inquiry was conducted.
Five screening committees.
5. I'm sorry, Lordship, 5. They have also participated. They finally could produce, because those who were receiving salary for even 1 month, they were considered that will regularize them. As a result, Lordship, we have verified their status, whether they receive salary for even without appointment, even without recruitment. We are very liberal in 2018 to close this whole illegal chapter forever. They participated and they were finally found that they received salary at some point of time. And as because they received some salary, so they fulfill one of the criteria. So they were regularized commensurate to their educational qualification. They do not have the proper educational qualification under the rules to become a teacher. So they were regularized. Government become very lenient to regularize them to the post of tutor, and given them certain period of time, within that they can acquire the requisite qualification to become a teacher, which was given to them, right? So this is the position, Lordship. In this situation, they are not qualified to be a teacher, number 1, under the rules. They were backdoor entries. There is a scam. They could not produce the documents which the division bench have directed. Only in 2017, they got another order. So we have 2 options left, Lordship. Either to pay them salary or we file a review application of 2000 or an appeal against 2017, because we want to close the whole chapter. Therefore, not only him, about 10,000 such persons were either regularized or totally dismissed. And those were found to be having proper recruitment process, follow the recruitment process and the qualification, they were regularized as teachers. That was done in 2018, 19, and 20. So this is our position. There is no willful violation of the order, Lordship. They have taken the benefit. Why they have participated in this inquiry process in 2012? The simple reason was that they could not furnish all the materials which were directed by the division's bench to produce before them.
The fact that the division bench issued a direction and they could not comply with that.
That should have been the end of the chain.
No. Is it documented anywhere?
Sir, a order, most probably, Lordship, in this order of 27/3/2014, that order, Lordship, I will have to procure, because the writ petition is not with us right at this moment. Maybe my friend is having it, is in his record. Maybe he is having. So we can see it, look into it.
You give me the writ petition number.
Writ petition number is, Lordship,
3286 of 2014.
yes.
Pardon me?
Writ petition 3286 of 2014. Gopal Chandra Borua and 18 others.
Just a moment. Give me 1 minute. Name, what writ petition number?
3286 of 2014.
3286 of 2014.
14.
Name of the party is
Gopal Chandra Borua and 18 others versus State of Assam. Maybe it is in the Lordship's record itself.
Gopal Chandra Barwa versus State of Assam and
Yes.
others.
So the impugn order in that writ petition is 27/3/2014.
27.
3/2014.
This is the impugn order.
That is the impugn order in that writ.
In that, and no, what you call the final order in this 3286 is dated
3286 is 17 to 2017,
17 to 2017.
Lordship.
Let's try to see. You say that it might be in the court record.
Yes, Lord. Yes, along with, because in the cause list, this case number is also reflected along with all records are before this.
Oh, that's right. Okay, 3286. Okay, repetition is available.
Yes. Yes. Oh, it are better no case. It was order 23 to 2011. 8582.
Mrs. Ona was the reason it will get the Mahalo. And others who will be saying about no payments. They have to say that they will require to produce people certified copies.
At least 750. See details.
Ona ko show কথা বলে
Una was 80%.
আদি এখন চলে এসেছে ওনা কোর্স নাই কি দুটানে আপনার মানুষ আছে কমাই পেলাম এই কনফিউশন থেকে যাবে এটা পড়মাছি পেটিশন নাম্বার যেটা নামকিটা সবছিল আরম্ভ হব ধর্মকান্ত মহন্ত কন্টেম্প ফাইল করছে গোপাল চন্দ্র বড়ুয়া নামকিটা উল্টা পুল্টা করে দিল কোনো বিষয় না এখন চ্যালেঞ্জ এখন তো কিভাবে অর্ডার আছে আমার দেখো আছে আমার তো
নামে
27/3/14 এলেভেল অর্ডার করলাম
one very interesting fact has been now discovered, Lordship. If Lordship is pleased to look at the contempt order, on the basis of the contempt has been registered, the 17 to 2017's order,
Yes.
Lordship will kindly see the party's name Gopal Chandra Borua and others. And here there are 18 persons. Total 19.
Just a moment. Yes, 19.
And the finally at page 17, the Honorable Court held consequently, the impugn order dated 27/3/2014 is set aside and quashed. That means this order of 27/3/2014 is set aside. In this writ petition against which the contempt is proceeding now, Lordship will kindly come to page 140.
140 of the
140 in the writ petition.
repetition means
Writ petition 3286.
3286. Yes.
Last page. The impugn order, Lordship will kindly say,
140.
yes, 140.
Yes.
Read the order dated 23/2/2011 passed by the Honorable Court in WPC 5/222/2008 of Mrs. Aruna Koch and 4 others.
Yes.
So Aruna Koch and 4 others, impugn order is this. And now the contempt is filed by Gopal Chandra Borua and 18 others. So mixing and matching, Lordship, the persons, creates whole confusion. The learned
No.
single judge also could not look into it. And the contempt case also, the notice could not have been issued actually. If you had pointed it out at the very beginning.
No, just-
কিন্তু অরুণাচল ভিত্তিক আমি তামিলকে নহলি করতে তো
Arunachal site and 5,208 If Lordship is having the record of 5,208, Lordship will find the names of all the 5 writ petitioners, which may be with Lordship's record now.
5.
5,222. 9, okay? No, it is not there, Lordship. But in any case, 18 contempt petitioners are not part of that impugned order. One is very clear. Aruna, Coach and 4 others.
But additional affidavit was filed, my lord. Additional affidavit was filed, my lord. Rectifying that, my lord, order, my lord. It is in the record, my lord. Additional affidavit was filed, my lord.
In which writ petition?
My lord, it is in the maybe record, my lord.
No, in the contempt petition.
3286, my lord. 3286, my lord.
3286.
3286, my lord. Additional affidavit was filed, my lord. Correcting the same, my lord. It might be in the record, my lord.
এই ইনফোটা কি গো আমি হেডফোন অর্ডার চ্যালেঞ্জ করলে আমাকে এটা খুলে ওটা
এখন কি এখন contempt case নিচ্ছি। এটা তো সব নাম আছে।
আচ্ছা এই যে কান্দি চ্যালেঞ্জ করেছি তখন রিপিটিশন যখন অর্ডার ইমপ্লিমেন্ট করেছে আসলে এটা নাম বলে না দিস দ্য উইল কেস এলেগো অর্ডারটার সাথে হিট অর্ডার সাথে আমার একটু কনফিউজ হয়ে গেছে
এই order set
এখন চ্যালেঞ্জ করেছিল বলে এটাও আমার কনফিউজ হলো যদি রিসোর্স দেখি বেশ আমাকে এটা দিয়ে দেন
I have got it.
বলা আমি মতো বলা মতো লিখে নাও 5,222
আমার কেস হলো 508 এটা তো 522 অর্ডার সাইজ আমাদের
উজ্জ্বল order আছে সেটা না
ডিভিশন বেঞ্চ অর্ডার করতে দিয়েছে এটা 522 করতে হবে
কারণ 222 সাইজ সেট করে না
দেখি এই অর্ডার
এই তো
এই অর্ডার দেখি এখন চেক করতে দিলে মানে
এই হতে নাই নাই
ইন্ডিভিজুয়ালি বসে আমি রিসোর্স একটু করতে আমি প্রাইভেট থেকে না অন্য এমএন করি বলে ওই রিপিটেশনটা রিপিটেশন একটু চেঞ্জ করে দিব
আমি রিভিউ করে বলবো
এটা কিছু তো
এই কন্টেম্পট নাই না
কন্টেম্পট লিস্ট কিন্তু কনফিউশন হবে আমি কন্টেম্পট
তোমার সাথে তো বলা আছে তোমার নাম তো কোথায় আছে কোনো কিছু নাই নাকি না কিছু নাই ইউ তুমি নাই
দুখন উইথড্র করে আছে দুখন আর্নিয়ালি দিচ্ছে এগুলি মধ্যে দুখন উইথড্র করা আছে দুখন উইথড্র করা আছে এখানে owner coach to manipulate CR 212 or যখন প্রথমে owner coach এর সাথে manipulate হয়েছিল এখানে আমরা বলে সার্টিফিকেট কপি করেছি it is still
জিরোটা
হ্যাঁ বিগুলিয়া ওখানে মত পড়ে owner coach মই যদি সার্টিফিকেট কপি করতে পারি বিগুলি লগানো কিভাবে গাড়ি উইথড্র করছে কিছু কিছু স্যালারি পাচ্ছে লাইসেন্স টাকা এগুলোর জন্য ইমিডিয়েট বিক্রি হচ্ছে
You will be arguing the matter, Mr. Nair will be coming,
Mr. Nair would be better if Nair is come.
then you please get him.
Very clearly, Lordship.
No, but he has pointed out something. And having read the writ petition, I believe the petitioner has a point. I'll show you why. In this writ petition, you may not have the file, I'm just sending it to
Lord.
you. You don't have the record,
Lord.
I'm sending it to you.
Now, I have taken a copy from him, Lord.
No,
I'll take a photocopy now.
writ petition.
Read petition, yes.
Oh, okay, then please come to page 17 of the writ petition.
Yes, Lordship.
You see this memo number is given at para 16,
Yes.
EHA 365-8251. That last page of the writ petition is a different number. So he has brought it on record by an additional affidavit. Last page, the memo is down below,
Yes.
correct? But I'll tell you what has happened. This affidavit was filed on 17/1, what do you call this, date is. This additional affidavit was filed on 19/1/2017. And the matter was heard on 7/2/2017. Correct. So this additional affidavit, there's no judicial order to accept it on board. That is one. And number two, the state was otherwise not aware that there's a change, because you see, the writ petition was not amended. And therefore, I don't know the law, you will be better knowing. Whether by way of an affidavit or writ petition can be amended, I don't know. This is something which both of you will have to address. That is why I'm wanting Mr. Nair to be brought for the submission. That is one part. And in the order, it is the impugn order which has been set aside. So impugn order would always be referable to something which is there as a part of writ petition. The additional affidavit, the state must have, whether they are prejudiced or not is a different issue, but they must know what they are dealing with. Therefore, to bring a document at the last end, they may not be aware, Education Department Council at that point of time may not be aware what is happening. Or they may have consented, we don't know. But whether by way of an affidavit, writ petition can be amended, a document can be altered or replaced, that is something which you'll have to argue.
And the base part is, Lordship, the most critical part is, Lordship, the impugned judgment has set aside this order of Aruna Koch. This order is set aside, not
No.
the other one.
No, that's what I am showing you, para 16.
Yes.
16 has a reference to 251. That Aruna Koch was different, but in this additional affidavit, which he has now
Okay.
produced, you should see that. That is also the same order of the same date.
But
You see that. Please give it to the Learned Advocate General. Last page here also, that 251, down memo below.
This is a typed copy. The original copy is not annexed. That is also very interesting because my friend has a story to tell about Aruna Coach also.
No, is it a type copy? I don't
It's a
know.
typed copy.
The copy given to us, please. It will be given.
Page 7.
Here it is page 5, then page 16.
No, the additional affidavit.
Additional affidavit I am filed on 19/1/2017.
Yes.
I have that page 5. There is no page 6. There is a page 16. I think it is 6, should be 6.
Just see this, the copy which I am having.
This is different and
Five zero eight five two thousand. We don't have this. Correct.
But here what has happened, Mr. Saikia,
Lordship.
still with all, everything, whatever is available, I think you'll find it very difficult to come out of this situation. In your affidavit filed in this writ petition,
Yes.
I'll hand over you the files. It says that the termination notice of the petitioners in CR 212 of 1987
Yes.
and COPC 105 of 1988
Lordship.
was kept pending until further instructions. The present petitioners were also issued show cause notice and their terminations were kept pending in accordance with letter dated 12/5/1992. This letter is by Deputy Inspector of Schools. I'll just give you this copy. And again in para, I have marked in pencil. Huh?
Lordship.
Again, in para 5, it says the termination of the petitioners herein who are also petitioners in CR 212 of 1987 and COPC 105 of 19 was kept pending until further instructions. You see, this would mean to show as if the petitioners were still working.
These were already there in the division bench. Thereafter, the division bench stated you furnish all those documents.
You show me the sequence because this is something which you'll have, I think you'll have to bring on record.
Yes.
At least a list of dates so that I can understand.
Lord,
Because
we'll do
otherwise
that.
I'll find it very
Because we
difficult to.
thought that after 2019, we are relieved of this problem. Because we have those who could be regularized, they were regularized. Those
Which document is fine or is available
Yes.
where?
Lords,
I think you'll have to do that exercise. You
we'll
see-
do Lords. Now we have a solitary case, so we'll do proper exercise.
No, that page I have flag marked.
Yes.
This is your affidavit.
2014.
Means what I understand from here that there was a termination order issued, but the inspector of school stopped it. Why we don't have an answer? So if that termination is stopped, it would mean that they are working, and if they are working, the Learned Single Judge rightly said that we give them their salary.
Then what about the division bench 2008 order? My Lord Justice Amitav Roy and H. Borua's order. That order is very important. So we may have to file a review application against this order of 2017. And they have also participated in the screening test or screening exercise.
Review, you know, how, what you call, because of the division bench judgment of this court, how far review can be now entertained after the gap of so many years?
5
Will
years,
be-
Lordship, but the thing is that if they do not have any legal entry,
No, I understand, but
there are a lot of Supreme Court judgments on that. First, they have to establish their entry was legal. Otherwise, public exchequer's money cannot go to this kind of people who are backdoor entrants.
but you see this affidavit, when there is a stay of the
We are
termination.
not disputing it. We are not disputing. But now the issue is whether, although our affidavit says they belong to this category of 752, we have, after the present exercise logic, they may not be within this 752. But in any case, we'll redo the whole exercise about this for 18 persons.
Mr. Sekia, sorry, Mr. Mazumdar, the officer present, you write their names so that we will dispense their personal appearance till further orders.
Lordship will kindly give us 3 weeks time here. We'll come with a proper response to everything, Lordship. What course we are going to take, or what, if we have to comply, we'll comply. This is not a very big thing, because 99% of the issue is already solved. These are leftover 1, 2 here and there. So we do not want that this particular issue should linger any further. And most of them are already overaged. I have seen their ages also. So in 2017 or 2014 itself, they were 60, some are 65.
Mr. Nair,
Lordship,
you opened up, it appears a Pandora's box
in the contempt proceeding.
in this contempt proceeding.
Only the thing I do not want that there should not be any person going behind the bar again. Lot of people are already arrested. Here also the impute
lord,
order says.
the-
These
CID
were the
case.
same arguments when the writ petition, my friend was not there. My writ petition was considered, these were the arguments.
No, but here now there's a change in some situations.
Lordship,
You see, number one, dates are very, what you call, weak in remembering. 19/1/2017, and affidavit was filed. Bringing on record in the writ petition, the changed document, which is the impugned order. In this writ petition, which is WBC 3286 of 2014, correct? On that, you see, this additional affidavit was not accepted on record. There is no judicial order for that. Number one. Number two is that
my
when
lord,
you-
one thing, madam, this is a contempt proceeding.
I know
If
that.
they had, they could have filed a review for that. They have not done it.
No.
This order is.
No, you
Lordship,
see,
Lordship.
it's totally different thing altogether. What orders can be passed?
That's
will-
my lord,
will come-
my lord's
come,
description.
at a later point of time. But now what has happened? The matter was heard, January it is filed. February the matter is heard. And the judgment is reserved. Now there is a substitution of the impugned order by way of an affidavit. I leave it to you to make a submissions as to
No,
whether
I'll have to just go through it.
whether the affidavit would amount to a amendment of the writ petition to bring on record a document substituted in a writ petition. We leave it to you for some other day. Now the fact is, if there is a division bench judgment, why I said that it's a Pandora's box, once opened, it can't be, what you call, conveniently, the lid can't be put back. Now there's a division bench order. Defense is now being taken that this division bench order requiring you to comply with to produce the documents was not done.
My lord Justice Amitav Roy's order. madam.
Yes, division bench judgment. So now faced with this situation, the fact is that even in a contempt proceeding, when an issue is raised about the illegality or otherwise, you have to also demonstrate that this is an issue which we can't take up in a contempt proceeding.
I'll come back to your lordship. on that. I'll come back to your lordship, but just for my lords, to apprise my lord, the order of my lord Justice Amitav Roy, the division bench, was a part of the records of the writ petition. It was never, my lord, taken away. or Mithal from the court. It was there and the court considered that while passing the order. Against that, my lord, there is a Supreme Court order in Dulu Devi's case, which was Dulu Devi, my lord. Supreme Court, same process, same issue. It went up to the Supreme Court. Supreme Court's order is there, and that Supreme Court order was considered by this honorable court. My lord can have it next week, any date, my lord, I'll apprise you.
No, we'll give him some time because I've asked the Advocate General to give the, because here there are many writ petitions
Lordship.
and traveling from one file to
Because
another.
what is happening, the problem here, my friend can bring it on record in form of an affidavit. My lord, I can also respond to that. Otherwise, my lord, daily, my friend is here today, fine. Today there will be something concrete arguments. But every day, one or the other points are being taken. How many
No.
will I meet, my lord? So let him come up with his
That's why
affidavit.
I'm formulating what issues if I'm there.
My lord will not form, my lord, my humble submission subject to what my lord would say. Let them file that affidavit and thereafter, my
No,
lord.
I'm not wanting an affidavit. What I'm asking is for a list of events with a document which is available in which file.
Lordship,
So
that-
it is easier for me to.
my lord will have that on record. A copy if can be given to me also, my
Yes,
lord.
yes.
Then my lord will formulate any questions whether this can be proceeded or not. Then on that day, my lord.
So for the time being, we are dispensing with the personal appearance of the officers.
No, my lord may dispense with it. No issue. But that
There are
dispensation would
four
not-
contemners. One is Bikram Phoike Lordship. He has retired and he has filed an application for his exemption. He has retired about 2 years ago. So he is not present, Lordship. An application has been filed for Lordship's consideration.
No, but he must demonstrate what he has done during his tenure.
He has filed an affidavit also.
Okay.
Then as Bhuya Lordship, the then director, he has passed away.
Yes.
Vijaya Chaudhary Lordship, she has filed an application for her dispensing because
I mean,
she
2
is.
days back, I came to know that in fact, he was my teacher at one point of time.
Bikram sir.
No.
Sanjeev.
Yeah.
Yeah. He passed away. Then Vijaya Chaudhary is not in office for last 3-4 months. She is ill. Still today, she is not working. And as Senapati, she is present at present director Lordship.
Okay.
So in a list, I am giving this Lordship.
My lord, the officers' presence are not required. My lord will consider the matter on merit knowledge. The officers will not be here.
But Mr. U.K. Nair, senior counsel, assisted by Mr. D. Bhuya, and counsel for the petitioners. Also heard Mr. D. Saigal, learned Advocate General, assisted by Mr. R. Mazumdar, and standing counsel for the Elementary Education Department, who's appearing as counsel for the respondent numbers 1.
Initially, one is, we are appearing for 1, 2, 3 and 4. Two is not there, Lordship.
Huh.
1, 3 and 4.
1, 3 and 4.
Lord.
Next paragraph. At the outset, the learned Advocate General has submitted that the respondent number 2, Sanjeev Kumar Bhuya, who was the then director of elementary education Assam, has passed away. Full stop. Accordingly, we strike out his name.
Lordship.
Full stop. In this regard, having heard the learned senior counsel for the petitioners, the name of deceased respondent number 2 is struck off. Next paragraph. The learned Advocate General has also submitted that the respondent number 1 has superannuated about 3 years. He's superannuated
Super.
about 2 years back, and he has filed an affidavit in opposition. And accordingly, it is prayed that his personal appearance be dispensed with. Full stop. It is also submitted that the respondent number 3 is unwell for some time, And she has been on extended leave for about 4 months,
About 4 months, I think
For-
maybe
for-
more little bit.
for around 4 months.
From January, she is on leave,
uh,
4
for,
months.
for about 4 months. For about 4 months.
January 17.
Uh, And therefore, he prays for exemption of personal appearance by respondent number 3.
That was about it.
Next, in respect of the respondent number 4, comma, Srimati Suranjana Senapati, comma, the present Director of Elementary Education Assam is present. Full stop. Next para, considering the submissions made by learned Advocate General, comma, the personal appearance of respondent numbers 1, 3, and 4 is exempted till further orders. Next para. In course of hearing, the learned Advocate General has referred to documents which are contained in the contempt petition, as well as documents which are contained in records of other connected writ petitions. Within bracket disposed of. So accordingly, the learned Advocate General is the learned instructing counsel for the learned Advocate General shall prepare a list of dates giving reference to the documents wherever it is contained, so that it is convenient for the court to peruse the records which are otherwise voluminous. Next, the learned Advocate General is for 3 weeks time to do that exercise. Next para. On the prayer made by the learned Advocate General, comma, the AOJ contempt section shall permit the Standing Council for the Elementary Education Department to peruse the records.
And also take photocopies, Lordship. Otherwise, we'll have to apply for certified copy.
Photocopies we can't, because under the rules we can't.
Then certified copy will take, Lordship.
We'll ask him to make notes that we are
No,
permitting him to inspect.
No, Lordship, we need to make submissions also on the basis of certain documents. Yeah.
For that, you I
We'll
think
take certified
certificate
copies.
will be able- To inspect the files, to inspect the files. Next para. After 3 weeks, give a fixed date.
Lordship.
22/5.
Convenient to you, both of you?
Lordship, Lordship. My friend is coming.
16th of May, Lordship.
22/5.
16th May.
16.
16,
16.
you want 16, okay. 16th of May.
Fine. Lordship.
Deeply obliged. So we have filed 2-3 IAs, Lordship, for dispensing.
Just. We have got only one on board.
1083 and 4610. 2 IAs, one by Pritam Pagya.
In respect of Vijay Chakravarti, she is respondent number 3.
Yes,
In that
1083.
respondent number 3, you said that in this regard, interrogatory IAC 1083 of 2023 has been filed.
10.
It is considered and allowed.
Pritam Bora.
As indicated herein after. Because in last paragraph, I said that dispense with till further orders.
Lordship,
So this-
the other IA is by Pritam Pagya, 4610.
Okay,
And he has filed a separate affidavit also, detailed affidavit.
in respond number 1, right? It is submitted by the learned Advocate General that IA Civil,
even
IA Civil,
40 long.
that number, please give me again,
4610/2023, madam.
4610/2023 has been filed. However, the same is not on board. The formal orders shall be passed on the next date
Lordship.
in this at IA.
Lordship.
But here I passed an order exempting.
Lordship. Much appreciated.
I may be delayed in 5 or 10 minutes in coming again at 2.
Quickly obliged for. এখন আর এখন
চাই আছো ৰবা, এইটো। এই শুনাচোন, এইকেইটা শুনা নি? এইকেইটা কৰক। Xerox কৰি পেলাই চব ফাইলছত আপোনাৰ ফোন নম্বৰ দি দিয়ক। এইটো নেকি? নহয়, তেনেকৈ মই লিখি দিম। কিন্তু মোৰ এইটো হয়, এইটো নতুন ফোন কৰি দি দিলে হ'ল। বুজা নাই? Part 2 and 6. So 1 to total. 1 to total.
রাকেশ জলদি ফটো লেগে একটা জেরক্স মারিব লাগে।
একদম দুৱাৰ মুখৰ কিটা মানে।
কোড নাম্বার 7 number
টু সাইডৰ আরে একদম দুৱাৰখন সোমাই পেলাই লেফট সাইডে তোমাৰ নরমাল কিটা থাকেতো। সো তাৰে ওপৰটো 2 আৰু 2 হল তাৰছত তাৰ সন্মুখটো 3 ইটো 4 ৰাইট সাইডে যিকিটা সাইড বার থাকে তলৰটো 5 ওপৰটো 6 এটা ওপৰ পাইছো কাৰেক্ট হ'ব না অনিব লৈছা দিয়া মো গৈ পেলাই টাংগাত ঘোঁৰাটো বান্ধোগে তাৰপিছত চল বসন্তী বুলি দৌৰাম মই কৈছো সেই বসন্তী নিচিনাকে মোৰ টাংগাত লৈ ঘোঁৰাটো বান্ধোগে আৰু এতিয়া টাংগাত এই ঘোঁৰাজনী কি ধান্ন বসন্তী নহয় ধান্ন তাল ধান্ন বুলি পেলাই বান্ধোগে সয়াবিন কালিও খুৱাইছে পৰহিও খুৱাইছে তাই সয়াবিন পালে তাক একো নালাগে
বহুত কি হয়নে এই ফাইলখন আমি নাই ভৰোৱা নাই ছাৰৰ ফাইলে বছৰ ফাইলে
Can we interfere with this, with the advertisement saying that this is qualification you should put, this is the qualification you should not, you should not put up for recruitment? Can that exercise be done by the court?
My permission is this, as per advertisement, the person should be a degree holder in music. But he is diploma holder, not degree holder, but I am the degree holder. And my appointment letter, Lordship may kindly see, earlier I was working in that higher secondary school. Since earlier, My appointment letter may be seen, my lord, page 33. I'll suggest to your lordship that I am better candidate than him, page 33, than her. Page 33, Sri Janak Losan Musahari, B. Music, son of so-and-so, is hereby engaged to act as music teacher to make up the stopgap lessons on demand of regular classes music students. This is made according to decision of the SMDC. The engagement automatically will be terminated when the selected candidate joins in the post. So this is my engagement order. Then, my lord, thereafter, the principal forwarded I joined in that school, that is page 34.
No, that is okay. Where is the appointment order of the respondent number 7?
Respondent number 7.
That is page 55, right?
My lord, first thing, my lord, respondent number 7 has not yet filed affidavit.
No, but his appointment order is at page 55,
Yes, 45. Now,
not 45, 55.
his appointment letter, page 55.
What is his qualification?
He is simply a diploma holder, my lord.
Where?
Yes,
Where do you find it?
subject to discharge at any time without notice and without assigning any reason thereof. Srimati Bina Brahma, care of so-and-so. So this has been appointed as music teacher and posted at so-and-so school. Now, lordship would see here, no qualification is mentioned.
No, but where is your assessment that he's not a B music? Where is
Yes,
that?
yes, my lord. That is my clear case. Kindly see, my lord, page 16, para 15. And that is not denied by her. And the government has filed affidavit, a state authority. They are also silent regarding her degree. They did not annex any document, simply stating that she is qualified, so appointed. How she is qualified? When my clear case is that she is unqualified. That should have been answered. Page 16, can you see?
Stated in our affidavit, lordship.
You don't say anything. You don't say anything. Except for
His qualification,
except for the qualification, you say everything.
except his qualification, lordship.
So then you set aside.
Lordship,
And my case was
lordship,
forwarded, my lord,
as
for
per
approval.
education, just I have seen, there should be qualification for music teacher, 50% should be in B music.
So you see, you have filed an
B
affidavit by 3, 4, 5, and 6.
Yes, Lord.
Is it very painful to write what the degree of the selected candidate is?
Yes, it is, I
Very
shall file
painful.
additional, Lord, I shall
Very,
file-
very painful.
Lord, I shall file additional affidavit.
But some cost.
Lordship.
The director of education must know how to write
No, Lordship,
affidavits.
earlier some mistakes was done, Lordship.
No, but
we
you see,
were-
why
Lordship,
you
I'll come back with
why you must have a
specific-
director if such an affidavit can be drafted by a peon?
Lordship, that person may not be there, Lordship. Kindly, Lordship, one
No,
more
but
time.
tell me, what is the?
I.
No, that's okay, Mrs. Vora. Every time, don't take responsibility. Please answer me. If this is the affidavit to be filed by a director,
Lordship, it is.
this can be effectually done by a peon.
Lordship,
Why we need the director then?
Lordship, because
Ask,
it's
ask your peon to man it.
Lordship, when if that person is not
This Ravi
available
Shankar
now,
Borgiari
now not
is a
available.
director for no purpose.
Yes, Lordship. Now he is not holding the post, Lordship, kindly, Lordship. That respects, Lordship, kindly allow me 1 week time to file detailed affidavit, Lordship.
Better file it.
Lordship, I apologize, Lordship.
Mr. M.U. Mahmood, learned counsel for the petitioner, has pointed out that his case is that the respondent number 7 did not hold the degree of B music to become qualified to be appointed as a music teacher in the school in question, pursuant to the advertisement. Full stop. In the affidavit in opposition, it has also been shown that in the affidavit in opposition, the then director of BTC who had sworn the affidavit, namely Ravi Shankar Borgiari, RABI, SANKAR, BORGAYARI has not disclosed the educational qualification which the respondent number 7 was having. Full stop. Next one. In this regard, the court does not appreciate the shoddy affidavit in opposition filed by an authority like the Director of Education BTC, who has not contributed the basic point raised by the petitioner. Full stop. On a the court has refrained from passing any adverse remarks against the Director of Education BTC on the prayer made by Ms. R. Boro Boral and its standing counsel for the BTC. However, it is provided that within a week from today, the Director of Education BTC shall file an affidavit, additional affidavit in opposition to disclose the educational qualification which the respondent number 7 had at the time of her selection and appointment as the music teacher in Kokrajhar Government HS and MP School. First of, the said authority shall take notice that in the event the disclosure as indicated in this order is not made, the said authority shall be ready to face the consequences which may follow the order to be passed in the next date. Next, the learned standing counsel for BTC shall send a downloaded copy of this order to the Director BTC. Bring the order to the notice of the said authority. List on, give after a date after 7 days. 8/5.
Lordship, deeply obliged, sir.
One simple
Lordship.
one. At the time of advertisement, what was the degree? Lordship has said
At the
that
time of appointment.
appointment, but appointment, advertisement time, he may obtain the degree later on also. So at the time of advertisement,
Applying. At the time of applying.
yes.
Okay.
Lordship, can I get uploaded order to the Lordship? Uploaded order?
I think you should, subject to
Lordship,
my signing it,
Lordship.
because you see at, today I'll be rising at 3:50. There's a meeting scheduled at 4.
Lordship.
So
Tomorrow.
if I finish that meeting on time and then sign it by the time it can be uploaded. Or tomorrow you can get it from the
Yes,
postmaster,
yes.
if not today.
Lordship. Deeply obliged.
15. Lordship, probably the matter might have become infectious. It might finally
Yes.
sometime to get updated instruction whether the.
Last time we adjourned for that only,
Yes.
you're
Yeah,
not getting
we were able to
instruction.
ascertain whether cause of action is even alive or not.
Okay. Mr.
NZ Chaudhary.
N. J. Chaudhary. Learned counsel for the petitioner. Waits for adjournment. So as to enable him to obtain instructions as to whether the subject matter of the rate petition is alive or not. Matters is adjourned today. Let's start for 4 weeks.
Much obliged. 36.
Yes,
Lordship was
he has got that instructions.
Lordship was pleased to direct to appear the concerned officer. Which
Oh,
was
he is
at-
present?
Yes, your lordship.
Okay.
Lordship, one error had occurred on that day, your lordship. Lordship, you are pleased to search the GR case number as 67/2010,
Yes.
but that concerned GR case number is actually 903/2010, and the same has been disposed in the on dated 22/1/2020.
Okay.
But that 67, it got disposed in 2015, your lordship.
Yes.
But this particular case, which is connected with this matter, it got disposed on 22/1/2020, your lordship. Acquitting the concerned, same order only, acquitting the concerned accused, your lordship. The now present principal had filed an complaint case with regard to loss of the records, your lordship. Due to which the scrutiny committee has not been able to come to a finding, your lordship. That is the tussle here in the matter.
Case was not 67,
Not 67.
but in the record, we find 67.
Lordship, that is the FIR number. FIR number it has been recorded as.
Sir, which page was that?
Uh,
Which page was that? That was in your reply somewhere. No, this reference to that case is in which document, Mr. Deori?
Yes, lordship, I forwarded a communication, your lordship, based on that, your lordship searched out. Just inside, left-hand side, up GR number, and in that
Here is 903.
column.
Okay,
At
so
the
it's
top, yes,
2020.
yes, your lordship. 903/2010.
You are Mr. Hemanta Kumar Rajkumar.
No, I think he is the present in charge inspector.
No, he retired. Was there for 2 months only.
Oh, you are Mr. Ratul Kumar Das. Who are you?
I'm Hemanta Prasad Raj.
Hemanta Kumar Rajkumar. Okay, the inspector of school Dhubi.
Holding in charge of inspector of schools in 2018.
You see, in this contempt petition, you are accused of non-compliance of the order of this court dated 6/6/2017 passed in WPC 5587 of 2017. Now, in this case, there was a direction that the district scrutiny committee shall call for the records of the governing body of the college. Now, we find that a case was filed. An FIR was filed. They're saying that the records were not provided by the earlier incumbent. And so therefore, this GR case was lodged. We made a mistake in recording the case number. But this case was dismissed, you said to 2020.
2020.
The case was dismissed on 2020. Therefore, please tell us, how do you propose to proceed in the matter? If you are comfortable with SMS, you can speak in SMS. We wanted to know from you, how do you propose to proceed further? Because in light of the contempt petition, so Deori, you can explain to him
Yes,
so that he
Your
can,
Lordship,
make his
as
response.
he has delivered to me, Your Lordship. Lordship, the order was of 2017. He was therefore in that in charge post. He was actually SDO at that time in Dhuburi.
Okay,
So he was there for only 2 months at that period
okay.
in the year 2018. So Your Lordship, now the present post, which was on last order, it was recorded as Ratul Kumar Das. He was also till 3/1/2023. Presently, the post is being held by one Dhrubajyoti Das. I had gave the complete details of that. He is now ADC. He is in charge to the my senior petitioner friend. Your Lordship.
May I suggest one thing? Since the present incumbent is different and he is no more there. Originally he was there. I propose to complete the present in charge inspector and the principal of the college as party respondents in the case.
You do it because you'll have to give a notice to them to comply
Yes.
with the order of this court,
Yes,
and then you file an application. So we exempt his appearance then. But now you know, Mr. Deori, how to advise your authorities. The complaint case has been dismissed.
Yes, 2020.
So if the case is dismissed,
Yes, Your
then the department must know how to
on that plea
how to
only, they
proceed
are not,
against
they
the
are not producing the
against the
records.
authorities. Because
On
the
that plea only.
principal on his own accord went to file the complaint case.
And on
complaint
that plea, they are
case-
telling that we are not getting
Complaint case
records.
is otherwise not maintainable without lodging of an FIR.
Hmm.
He files this complaint.
On the basis of that, one FIR was.
On the basis of that, it was
Yes.
filed, but that is against the against judgment of this court as well as Supreme Court of India
Yes,
under 156(3).
yes.
The magistrate cannot direct the what you call lodging of a case unless an FIR otherwise had been registered.
Yes, Your Lordship.
Priyanka Srivastav.
Yes.
Okay. He was from which period to which period?
Of the position of the Janto.
January to March
2018.
2018, okay. But Mr. DP Chaliya, I'm a senior counsel, assisted by Mr. UP Chaliya, M. Rana, learned counsel for the petitioners. Also, Mr. B. Deori, learned counsel for respondent number 1. Next para. pursuant to order dated 3/4/2023 from Mr. Hemanta Kumar Rajkumar, the then Inspector of Schools, Dhubri, is personally present and has submitted that he was at the relevant time posted as subdivisional officer, Dhubri, and was the in charge inspector of schools for a period between
January.
January to March 2018.
January to March
2018, your lordship.
18. And he has submitted that the present incumbent to the office of the Inspector of Schools, Dhubri District Circle, who is also the Secretary of District Level Scrutiny Committee, Dhubri, is Mr.
Lordship, Dhrubajyoti Das at present,
Dhubajyoti Das,
ADC Education.
ADC within bracket Education.
Is there now Inspector of School?
Next para. The Learned Counsel for Respondent number 1 has submitted that there is an error in order dated 3/4/2023, wherein GR case number 67 of 2010 was referred to. In the said connection, it is submitted that instead of GR number 67 of 2010, the case number ought to have been Fakirganj PS case number 67 of 2010, corresponding to GR number 903 of 2010. It is submitted that the proceedings of GR 903 of 2010 was dismissed by order dated.
Lordship, I had forwarded your lordship.
Okay.
The
Just give me the date.
Yes.
Date should be there.
Oh, Acha, this one.
Yes.
This.
Yes. There,
Okay.
close. It is there.
Okay. Case was dismissed.
Closing date, your lordship.
By order dated 22/1/2020. Passed by the learned Chief Judicial Magistrate, Dhubri, resulting in acquittal of the accused.
Yes.
So accordingly, the inadvertent error appearing in the order dated 3/4/2023 in referring to GR number 67 of 2010 stands rectified, and the said in reference to the said GR number 67 of 2010 shall now be read as Fakirganj PS case number 67 of 2010, corresponding to GR number 903 of 2010, disposed of by order of acquittal dated 22/1/2020. Next para. Having regard to the statement made by the respondent number 1, Hemanta Kumar Rajkumar, his personal appearance is dispensed with till further orders. Next para, the learned senior counsel for the petitioners. Praise for is granted time to put the present incumbent to notice of complying with the order dated 6/6/2017 passed by this court in WPC 5587 of 2017 and thereafter file an implementing application. Mr. Madison adjourned today, lists this along with the interlocutory application for implementing as and when filed.
Lordship, I was supposed to incorporate a principal also perhaps. By senior has forgot my. The senior, he was supposed to incorporate a senior, the principal of that college.
Ah.
He is the concerned person which will be required.
Incumbent as well as the principal
Principal
of
of the
the
college.
school in question. Okay. I'm returning back this.
Yes,
copy.
yes.
Your personal appearance is dispensed with
Yes.
further orders.
Oblige, your lordship.
16.
Instruction.
What is the age of superannuation? She was a subject teacher, postgraduate PGT.
Usually 60 madam. Is it about blank?
And was the in charge principal. Age will be 60.
60 madam.
So this is 2017. He was 56 then.
Past that. And the.
But this remark, I think, should go.
But even if it goes or it does not go, my lord, her career now being over, cannot have any effect anyway.
No, it has the effect. It has the effect.
The remark, my lord, I do not find it there in the order passed, just somewhere there in the inquiry report. In the order that has been passed, if lordship comes at page 24, I do not find that remark anywhere.
Okay, it's just. But that deep even I did not read. Oh, it is in the inquiry officer.
It is the inquiry officer who made a remark, but in the impugned order, there is just an observation that the inquiry report states that she cannot be the in charge principal.
That will have no
That has
bearing
not
on
been
it.
agreed to or rejected. Nothing has been done. Just that noting is there. Inquiry report says so.
None appears on call for the petitioner. However, Mr. R. Mazumdar and standing us for the
Secondary.
Secondary Education Department. Mr. Niyog, you are appearing?
No.
Yeah. He is present. Next, Pala. The case of the petitioner, in brief, is that she was holding the charge of principal of Bezera, BEZERA, HS school under present Kamrup Rural District, under the then Kamrup Rural District, since 24/1/2012. For a for an incident which took place in the school in the month of May 2015, the petitioner was placed under suspension and a departmental proceeding was initiated against her on 5 charges, including the charge of her incompetency to administer the school. Full stop. In due course, the petitioner was reinstated in service as subject teacher. Full stop. Upon receipt of the inquiry report, the Director of Secondary Education, Assam, within bracket respondent number 2, was the disciplinary authority, by an order dated 6/1/2017, exonerated the petitioner of all the charges, including the charge of her incompetency to administer the school. However, the petitioner is aggrieved by a part of the report of the inquiry officer, wherein he had made a remark regarding inverted commas in administrative incapability, bracket closed, of the petitioner. Next paragraph. Accordingly, the present writ petition has been filed under Article 226 of the Constitution of India for expunging the remarks of the inquiry officer. Next paragraph. The learned standing counsel for the Secondary Education Department has submitted that on 3/8/2017, when the petitioner had sworn the affidavit in support of the writ petition, he was aged about 56 years. So it is submitted that for a subject teacher, the age of superannuation is 60 years. Hence, it is submitted that there is every likelihood that by passage of time, the petitioner is already superannuated, and therefore, it is submitted that the observation made in the inquiry report would not cause any prejudice to the petitioner. It is also submitted that in the order of the disciplinary authority dated 6/1/2017, the said authority did not approve of the remark made by the inquiry officer. Hence, it is submitted that as the purported adverse remark against the petitioner by the inquiry officer does not find place in the order of the disciplinary authority, there is no way that the said remark may prejudice the petitioner in any manner. Next paragraph. In view of the nature of submission made by the learned counsel for the petitioner, for the standing counsel for the Secondary Education Department, now the court is of the considered opinion that as there is every likelihood that the petitioner is superannuated in the meantime, And having regard to the stand taken by the Standing Council for the Secondary Education Department, that the observations made in the inquiry report is not likely to prejudice the petitioner, as the same does not form part of the order of the disciplinary authority. This court is inclined to close this written with an observation to the effect that the remark made by the inquiry officer in his report dated 29/3/2016 to the effect that inverted comma start. However, comma, upon inquiry, comma, it has come to light that there was great animosity against the staff, which to a great extent was due to the administrative incapability on part of Srimati Mosfiara, Mosfiara Begum, inverted comma closed, shall not prejudice the petitioner in any manner. With the aforesaid observation, this petition stands closed. Yes, you've got instructions.
No, my lord, I tried to find out what has happened is the petitioner had approached this honorable court at a certain point of time, and there was an order that he selection to the grade 4 post of Chokidar be made after advertisement. There was an advertisement. Petitioner and others had participated in the advertisement, and my lord, thereafter the selection was not completed. It was kept as such till the year 2012. It started in 2010. Petitioner then approached this honorable court in the year 2012, challenging that selection process. This honorable court said that the select list is for 1 year, fill it up. This order was in 2015, that fill it up following the due process of law. In the meantime, my lord, there were other petitions filed before this honorable court, which has said that all those selections were held in the year 2004 and 5 for the same posts, although in different schools. They did not reach their finality, and therefore this court was approached. This honorable court directed that those selections should be completed as soon as possible if nothing is found wrong in the selection process.
Oh,
So this school's report had also gone to the director of the director with the comments that it was being properly held, and therefore keeping in view in those judgments, the respondent number, the private respondent was appointed.
but
Now
then you'll have to
petitioner
file an
challenges
affidavit. Now you'll have to file an affidavit.
Yes, madam, that
So without
how it
that-
came to this twist, my lord, why it was included in those batch, that I have to bring on record. Otherwise, this allegation that there was no advertisement at all is wrong. There was a selection process which was set.
That's not the case. The case of Mrs. Das is that the validity of the select list had expired,
Yes,
and therefore the appointments are not valid. That is what I understood from his petition.
yes. But in very similar cases, this honorable court had said that what had not been completed then, complete all those selections. This also.
Then
came
bring
in-
on record. Bring on record that.
My lords. Well, I'm just giving a view of the what has been told to me.
No, that is okay, but
I'll bring it on record, madam.
it has to be got on record. Hearing is not believing.
In this
Uh,
department, sometimes sight is also my lord questionable. Visuals are questionable at times.
I won't comment. Mr. S. Daslan, counsel for the petitioner is present.
Yes, ma'am.
Mr. R.
Yes, ma'am.
S. Nath, I'm sorry. S. Nath, counsel for the petitioner is present. Mr. R. Mazumdar Leonard, counsel for the elementary education department Grace for is granted 3 weeks time to file affidavit in opposition in the matter. Next para. The respondent authorities shall take note of the fact that this petition was filed on 26/4/2017 and notice of motion was issued by order dated 28/7/2017. First of all. Therefore, the respondent authorities are put to notice that in the event no affidavit in opposition is filed at least 2 days prior to the next date of listing, the court will be inclined to invoke the doctrine of non-traverse and presume that the respondents have admitted the claim of the petitioner. And accordingly, appropriate orders will be passed. Next, the learned standing counsel for the elementary education department may shall send a downloaded copy of this order to the competent authorities to bring this order to the notice of to their notice list. Give a fixed date after 3 weeks.
19/5.
Obligement.
17.
Please, your lordship. Due to some personal difficulties, the arguing counsel, Mr. B.B. has to leave the court, my lord. May I pray for any other date, my lord?
Just something I have to ask. Subject to what you say, I understand that the issue of the qualification of net slat, etc., has been put to rest by this court by various orders of the court. Even the teachers who at that point, earlier point of time, were not requiring the net slat, etc., they are all now subject to acquiring of that qualification. So, does anything survive in this
No,
petition?
no, subsequently, he has, my lord, acquired the, say, qualification, my lord.
Subsequently,
Subsequently, he
where
acquired,
you have
but
stated
his,
that,
my lord, claim is there.
where you have stated that, this is something I missed.
Actually, madam, I'm not prepared this case because I brief was with Mr. Goswami. So, madam,
Okay.
any other day, tomorrow or day after tomorrow, madam,
No, it will go after 2 weeks because time slots are already filled.
madam.
The prayer made by Learned Counsel for the petitioner, the matter is adjourned today, just after 2 weeks. Mr. K. Gogoi, standing counsel for the Higher Education Department. You are for
UGC. Respondent number
name
K. Bhattacharya.
K. Bhattacharya, standing counsel for UGC are present. Okay. Okay, Mr. P.K. Goswami, Dr. P.K. Goswami, counsel for respondent number 6. He is present. Okay. But Mr. Gogoi, just to understand this matter, this net state has already been decided by this court.
Already decided by
Okay.
even my lord also.
So that's why I'm just asking, that's why I put that query. Okay.
Even lordship exactly similar situation personal lordship. On 2017-2023 also, Honorable Court number 17 also decided that particular issue also.
Okay. I had some recollection, but
Lordship.
since I don't keep a track of the orders which I'm passing, I put that query. Okay.
Obliged.
Thank you.
Yes, Mr. Babuya.
Well, in this case relates to that, my lord, the petitioner before your lordship was appointed in the year 1989, my lord. Thereafter, my lord, his salary got hauled, my lord. Accordingly, he subjected a writ petition, my lord. During course of hearing, my lord, the writ petition operative part lordship will see at page 41, my lord. Operative part. It's a formal judgment, my lord.
Yes,
Operative part, my lord, I'm reading only, my lord. Taking consideration.
just a moment. Which page? Please give me the page.
The judgment, my lord, page 30 to 41, my lord. Operative part is the 41,
Page 41.
my lord, only operative.
Yes.
41, my lord, it is made clear that in the event of state respondent process to question the legality of the appointment of the petitioner, the state respondents would keep in mind the various orders passed by this court. One annexed as annexation number 51 to 56. In the instant writ proceeding, the exercise to be carried out by the state respondents for the payment of salary to the petition initiated and completed within a period of 6 months from today. And while doing so, the state respondent is at liberty to ascertain the period of the service rendered by each of the petitioners in view of the above petitioner petition stands disposal. Thereafter, my lord, and the next page 42, my lord, a list has been published.
I've seen at page 44, I marked it.
Yes,
Say,
my lord.
page 1, 2, 3, 4.
My lord.
One is 730 days check received.
My lord. Apart from this, my lord.
Appointment not existing.
My
Not
lord.
existing, not existing.
Yes, lordship
Yes.
will see page 46, my lord, serial number 11.
46.
46, serial number 7,
11.
my lord.
Suresh Samua.
Yes, my lord. Suresh Samua have been shown 2012, 349 days, my lord. In a year, 249 days, my lord. How is it possible, my lord? Lordship has got it.
Yes.
For the year 2012, 394 days.
There's some error somewhere.
Yes, apart from these also, other thing also is there, my lord. Lordship will see page 49. Page 49, serial number 25.
Page 49.
49, serial number 25.
No, that's okay. Some
Here
mistakes may
also-
happen here or there.
Here also, my lord, they have shown particular year 414 days.
It's okay. You see,
A year is not, my lord,
not
360.
going by this mistakes,
My lord,
but the substantive part is that the posts which are shown, is a non-existing post. That is the main crux.
my lord. So to that effect, my lord, the state respondent affidavit is an requirement. Other anomalies also there, my lord. I'm not pointing out at this moment, my lord.
Let's just tell us so that we understand. You see, making of mistakes in numbers, that happens. That is the only anomaly.
No, my lord, not that one. This, my lord, my anomaly, it reveals, my lord, I worked throughout the year and they shown me, my lord, particular some dates. Not only me, my lord, some other petitioners also, other persons also. So in this case, my lord, they need to have filed the detailed evidence from where they got the data. For the random sake, my lord, lordship is taken into page, my lord, any one of the petitioner, my lord, lordship can look page 44, serial number 2.
You see,
Serial number 2, my lord,
No, no,
1199 days, my lord. They are counting from 2008. While calculating this thing, my lord, they are silent, my lord. How come they got the figure? What about the holidays, Saturday, Sunday, other holidays? They just straight away came away to the picture that 1199 days for serial number 2 at page 40.
yes, Mr. Mazumdar.
My lord,
They have to disclose.
I have received some instruction in this matter. To the extent that, my lord, although all the repetitioners have been offered appointment as tutors, and my lord, 11 numbers have also joined in their service, giving up all their past claims. 6 persons, my lord, the 6 of the petitioners, that is Hemoprabha Rabha, petitioner number 4, then one Bharati Lahon, Gitanjali Kaur, and Tulon Dotto, Debojani, Tamulian Umen Dotto. These are the persons who did not, who have not joined as per our instructions so far. But the other persons have joined, 11 persons have joined.
Okay, we can segregate those people who have joined.
Yes,
My lord, let
But-
them file affidavit, my lord. I have no instruction on that.
No, it's okay. Once he says that we accept it for the time being. But
For the moment.
Himoprabha Bora, that
Number
is
4,
4,
number 4, number 5, number 7,
7.
number 8, and Debojani,
There was a
number
9. 9.
and 17. These 6 have not joined.
6 have.
Not joined. They were offered the appointment,
It's okay,
but they have not joined.
but let us assume that your instructions are correct.
My lord,
So insofar as these 6 petitions are concerned, at least you will have to show that.
I'll have to give the.
What about the salaries also, my lord? The case was basically for the period of salary, my lord. From
No, that is okay. If the others have joined, accepting what you call forgoing their
that, I
part,
have no instruction, my lord.
we take it
Let
from
them-
him.
Let them submit a copy upon me, my lord. I'll take it,
We take it from him.
my lord.
Uh,
Without prejudice to the rights of the petitioner, my lord. If it happens, they have not joined.
No, not without prejudice now. If she had accepted, why should the court give a,
No, my lord.
Right,
If it is accepted according to him, my lord. I'm the conducting petitioner. I have no
no,
instruction.
that's okay. Let him file that affidavit.
Yes, yes.
Because I
Yes.
won't make.
That's what I want. my lord. Along with the data,
institution
my
level.
lord, how they got it.
It's a.
Both sides are duly represented. Having regard to the fact this writ petition was filed on 4/8/2017. And notice of motion was issued by order dated 9/8/2017. The respondent authorities are provided a last chance to file their affidavit in opposition. That is 2 days prior to the next date of listing, failing which the matter will be heard on the basis of materials available on record. Next, the learned, Mr. R. Mazumdar, learned standing counsel for the this is elementary education. Elementary Education Department and shall send a downloaded copy of this order to the corresponding authorities to bring it to their notice. List on after 4 weeks, give a date.
26/5.
Affidavit at least 2 days prior to the next date of listing.
It's fine.
Jang lagaইছে স্কুল construction province wise
None appears on call for the petitioner. How Mr. M. Islam and counsel for the respondent number 7. And Mr. R. Mazumdar and standing for the Elementary Education Department and Mrs. D.D. Bora, Learned additional senior government advocate. Appearing for
5, 6.
respondent number 5, 6. 5 and 6 are present. Mr. Islam for 7. Make it in serial order. And elementary education is 1, 2, 3, and 4. It appears from the statements made in the writ petition that dispute relating to the use of land
Yes.
or purportedly belonging to Badlichar, Badlichar LP school. Is raised in this writ petition. And it apparently appears that it's a purely a civil dispute. So it also appears that in respect of the said land, proceedings under section 133 CRP was also registered as MC 395 of 2013, where certain orders were passed by the additional district magistrate Mangalday on 9/11/2013. First up, the grievance of the petitioner is that the school authorities have started building construction and it is claimed that the said construction is in the middle of the Idgah field. So therefore, court is inclined to put the petitioner to notice as to why a purely civil dispute with regarding to the ownership and use of the land be taken up in this proceeding under Article 226 of the Constitution of India. First up, the learned counsel for the respondent shall also make the submissions on the said point on the next date of listing. Next paragraph. As the petitioner is absent on call for range of justice, the matter stands adjourned today. List after 2 weeks.
And 21.
Complex. 2021, I have received some instruction, but they are not, since it's a disciplinary proceeding, they are not complete.
Mr. Gupta is waiting since 2018. Mr. Mazumdar,
I understand.
the doctor is waiting since
But-
2018.
My lord, yes.
The records will also be necessary, my lord.
Just with this,
Lordship, has it sometime in May, my lord, with the records also perhaps? Go ahead.
In fact, my lord, earlier I was dismissed from service, my lord, that was interpreted by the
So,
Supreme Court.
what I understand is that he's now only agitating about his unpaid salary, nothing more.
No, my lord, I've been
He has been
subsequently
terminated.
dismissed from service, that's also challenge. I've been subsequently dismissed from service, my lord, that is also under challenge.
There are two writ petitions,
Two
my lord.
repeations, my lord, 1370.
18 and 19.
Oh, no, I was not that smart. I read only the first brief. First brief is only for the salary. Okay,
And when that writ petition was pending, his disciplinary proceeding came to an end and he was terminated.
okay, so the
this-
termination is also under challenge.
Yes.
That
And
is
the-
2019 matter.
19, my lord.
Okay, I did not read that. Okay,
It suffers from the same vice, my lord, which the earlier one suffered, my lord, and it suffers from the same vice, my lord. So therefore, the records will be necessary.
okay, then records. Uh, Reading files alone is difficult. Mr. Abdul counsel for the petitioner and Mr. R. Mazumdar and its standing counsel for the secondary education department. Next paragraph. In WPC 1284 of 2018, the petitioner claims non-receipt of his pending salaries for the period on and from which he was put under suspension. Correct? Your salary you are claiming from this date of suspension.
My lord, no, since
Post is-
8/1/2018, my lord.
Since
8/1.
8/1/2018. Okay, 8/1/18 means reinstatement.
Reinstatement.
After reinstatement,
Yes,
correct? Please check the records.
my lord, I'll just.
It's that is after reinstatement of the petitioner in service, after he was put under suspension.
Yes, well, after I joined, after being reinstated, I joined on 8/1/17. my lord.
Okay, okay.
Yes.
First of all, it is submitted that during the pendency of the said writ petition, the departmental proceedings had culminated and the petitioner was removed from service, right?
Dismissed. my
Dismissed from service. Pushpa, the departmental proceedings as well as the order of dismissal from service is put to challenge by filing WBC 1370 of 2019. Next paragraph. In this case, no affidavit in opposition has been filed. In WPC 1284 of 2018. No, in both the cases not filed.
Both cases. not.
In both the requisition it is not been filed. So accordingly. The respondent authorities are at liberty to file their affidavit in opposition at least 2 days prior to the next date of listing, failing which the matter would be heard on the basis of materials available on record. Next para. The respondents in the secondary education department shall without fail, produce the records of disciplinary proceeding initiated against the petitioner. Which is. Which was culminated. By. The impugned. Order dated 3/1/2019. Next, the Donald Standing Constable for the Secretary Education Department shall send a downloaded copy of this order to the competent authority. Sorry, this is elementary education, not secondary, elementary education. Shall send a download of order to the competent responding authorities so as to secure the records for protection before the court. After 4 weeks, give a date.
Yeah, fix it.
29/5.
Deployment. Oh.
22.
May I please, Your Lordship?
Yes.
Lordship, in this matter, as per our information, the previous committee has been dissolved. In this matter, the previous committee has been dissolved and no new committee has been formed. So matter may be disposed of with the direction to the head teacher to allow the petitioner to sign on the register as cook and to release her arrear salary for the previous 5 years.
Where to be? Withdraw করে থাকা না এটা বেলে কিবা কৈ আছো নোৱাৰে কি বুঝলি ওয়েলকাম ওয়েলকাম
Ms. Yunandar and counsel for the petitioner submits that during the pendency of this petition, the petitioner has been permitted to resume as cook
Yes, Lordship.
in the cook cum helper in number 191 Desha Bandhu DESHA B and DHU Memorial LP School, comma Keukona KEUKONA District Karimganj. Stop. However, committee submitted that direction be issued on the responding authorities for release of the
more to continue to do that.
remuneration which is due to the petitioner. Next paragraph.
Only for now.
As the main issue raised in this petition has been resolved by permitting the petitioner to resume his service as cook cum helper. And the court is of the considered opinion that if the petitioner has any claim for his for her remuneration, it will be open to the petitioner to raise the claim before the competent authority and then pursue it.
Lordship, may I say something? The petitioner may be allowed to sign on the attendance register.
No,
This
no,
may
you
be-
see, we can't do that. If you have resumed, they will be signing it,
No, Lordship, she is not allowed to sign on the register.
then we'll have to adjudicate. Because you see, once you join, that means you joined. But if I am directing them to allow it to join, to sign, that means I am doing something which is the circumstance which is not before us. You see, my secretary is here. He's attending and doing his duty, but I'm not permitting him to sign. You understand the consequences now. How will the salary bill be, what you call, be processed?
Yes, yes. Even though she is doing, but actually she is not allowed to.
No, you see, everybody likes what you call honorary person working with them on honorary basis. If somebody comes and tells me that I am starting to sweep the floors of the court, your courtroom, I'll keep it speak and span, I'll take no charges. Maybe even I'll permit him. If I'm not giving him any appointment letter, I'm not allowing him to sign. Therefore, I permit him to do that work voluntarily. If I have the opportunity, I will take it. I don't have that opportunity because everything in my courtroom has to be recorded. I don't get that opportunity, but assuming I get an opportunity, I'll take that privilege. But to allow you to sign needs an adjudication on merit. Then you argue on merit then. You see, there is a reason to take that view. On the last occasion, we took a preliminary note in the order dated 12/4/2023, saying that whether that your grievance in this writ petition as well as in the contempt petition is that your claim is that respondent number 5, who is the president of SMC of 191 Deshbandhu Memorial LP School, did not allow you to join. Correct. Now, because of that, we raised a query as to whether a writ can be issued against respondent number 5, who is a private person. So now you are taking a stand that the issue is resolved.
Yes, yes, yes.
But according to me, that is the dispute that somebody did not allow you to sign to join still remains because you're not allowed to sign. How can I issue a direction against an individual?
Lordship, we have made respondent number 6 as a party also, in the prayer also we have mentioned about him.
It is not your grievance that the principal is not allowing you to sign it. You say that the president of the SMC doesn't allow you to join.
Lordship, kindly, we have said, also mentioned about the respondent number 6 as well.
No, respondent number 6 is there. There is no difficulty in that. Your prayer is also respondent number 6. But what about your statement? You are saying that the respondent number 5 did not allow you to join. You are saying that your specific case is that the attendance register are in the house of respondent number 5.
Yes, Lordship, it's taken in the house of the respondent number 5.
I understand. That is why you see, that is why I have posed that query in the last order.
But the committee has also been dissolved and no new committee has.
No, I understand, but you see, if I am to pass an order, I have to take responsibility of the order. Even right order, even wrong order. I have to take responsibility of it. Because if I pass orders mechanically, the second point would be that there will be a contempt. Again, there would be rejoinders, affidavits. Again, there will be a second round of writ petition. So that's what I am saying. If you have joined, if you have a claim for your salary, you raise that claim. But if you don't have that, then the authorities will do something. Mr. Mazumdar? Mr. Mazumdar, what do you say?
Otherwise, the president not allowing her, that aspect remains. If she's attending the school, the records would always be there.
But that is what
Should
we are
there be a
doing, sir. That
direction
is why
where-
we are deliberating.
Can there be a direction to allow someone to sign the attendance, she'll come back 5 days later on saying that I'll sign for the 5 days because there is a court order. Those kind of disputes will come up later on. Things are taken to another level by parties. I'll be. So once she has been allowed to join, if that is the statement, without there being a statement that I'm not being allowed to sign.
Mr. Barbuya is tensed. Something is cooking up.
He is the president.
I am the president.
Come here. No, your expression shows that something is cooking.
Yes, I am not there now as on date. New president has come.
Yeah.
And after that, during my period, I allowed as per information, and my learned friends also, she was allowed to join. And putting signature in between headmaster and the petitioner, the attendance register with the headmaster.
No, her case is that you
I
take
am
the.
not allowing her.
You, no, he's not question of allowing her. He said that her attendance register you are taking home.
That time there was that dispute resolved by the district elementary officer. I find in the documents, lordship. But now I am no longer the president of the school. New president has come, lordship. Managing committee for a period of 3 years. It is 2017 matter, lordship. New president has come.
So, Ms. Nanda, what do you suggest? We keep it
The
pending then.
lordships
We keep it pending.
matter, your lordship may direct the district elementary officer. He is also hold the charge of SSA, and midday meal is regarding falls under SSA. The direction may be given to district elementary to consider her grievances if he was not allowed to put a signature in the attendance register.
DEO for a cook. No. He has got plenty of work to do. DEO can't be directed to look into
Put
those grievances.
signature.
We adjourn the matter, you take a call, because I made my mind clear.
Lordship, okay, then any date may be given.
List after week, all sides are duly represented, list after week is paid for by Ms. Yoon and the counsel for the petitioner.
Lordship,
After request.
Take a call. I'm not giving a fixed date because we are too tied up. After a week, I've said,
in the month of June, perhaps any date may be given,
we want it in June.
or May and last week of May. But any date may be given, lordship.
29/5. 29/5.
29, right? Obliged.
Yes,
Item 23.
Made with your lordship.
there are a few bail matters. Is the APP present?
Last. Made with your lordship.
Okay, the APP is not there. Okay.
Last occasion, your lordship order, my lord, by order dated 10/3/2023, my lord.
Yes,
The lordships directed to the last line,
yes, 35 students. Yes.
10/3/2023. It is made clear
Mr.
that
Muzumdar, you have the instructions.
Well, it is,
again,
last
one
occasion,
day come, my
Mr.
lord.
Mr. B. Kaushik was required to, they have filed an affidavit on a similar matter in another matter, my lord. Affidavit has been filed. He also has knowledge, my lord. We'll bring that affidavit, file it on this. And then it's a.
You want to rely on that affidavit?
Yes.
Can you Just have a copy.
Yes,
of
I'll
it?
serve a copy of those.
Okay.
Mike is to Delhi. Different amount of affidavit. Again, he may file affidavit in my case, my lord.
No, if you want to rely on it, he just serves you a copy.
My lord, cannot, my lord, I cannot go, reply, my lord. I cannot file reply if I.
We'll file an affidavit, my lord. Based on that, we'll file an-
Definitely you can, because it will be by the orders of this court, when you are relying, you're giving a copy,
My-
you can respond to it,
My-
definitely. We permit you to do that. We'll permit you to do that.
Last two times, my lord, two occasions he has taken times, my lord.
No, it's okay. That's why in order to shorten, because if he says that he'll rely on the affidavit, means that it is only a legal issue which he'll take up. So we'll permit you to respond. Mr. N. Boran and counsel for the petitioner is present. Petitioners is present. Mr. R. Mazumdar and a standing counsel for the Elementary Education Department submits that in a similar matter, an affidavit is in opposition has been filed. And it is submitted that the Elementary Education Department would rely on the said same affidavit for the purpose of this writ petition. Next paragraph. In view of the said submissions, comma, the court permits the Elementary Education Department to rely on the affidavit in opposition filed in, you have the case number? Filed in so and so.
In a interlocutory application, we have filed that affidavit, my lord.
No, you have you have any numbers?
I can give a, I need 5 minutes.
You give it to the court master.
Yes,
Just write that, whatever is there, IE or something, whatever. In view of such submission, the court permits the said affidavit to be relied upon in this writ petition. Full stop. However, comma, to ensure that the petitioner does not suffer any prejudice, comma, the petitioner is permitted to file their affidavit in reply, if so advised. In connection with the said affidavit. Next paragraph. Copy of the said affidavit will be furnished to the learned counsel for the petitioner within 2 days.
Well, writ petition number 351/2022, my lord.
Okay. Reply if any within
2 weeks time, maybe,
within 2 weeks.
because of that coming from the Samadhi, my lord.
List the matter after 3 weeks.
My lord. 3 weeks.
2 weeks. No. Within 2 days, he'll give you a copy.
My lord,
2 weeks for your reply.
my lord.
Listing after 3 weeks.
March.
Mr. Mazumdar, can I also add that you also have the liberty to file in this case also? Just add there, huh? In the alternative, the Elementary Education Council is also at liberty to file affidavit specific to this writ petition in the end of this.
He wants a copy of the writ petition. He wants a copy of the writ petition. I am saying that your copy of certificate copy.
Item 24.
May I bring the lordship? Lordship, I am telling you 2 weeks more time, lordship, book to communication gets like, contact my clients, lordship. So I, in this case, finally, comment of.
Okay. Both sides are duly represented on the prayer made by the counsel for the petitioner. The matter stands adjourned today to enable him to obtain instructions. List after 2 weeks.
Keep your next.
25.
Yes,
25.
In bail matters, who are the petitioners counsel? Can you see the APP is available, because I'll be rising in 10 minutes. Let's try to find out if any APP is there in any other court. Just give a scroll for the APP. Mr. Das, give a scroll for APP. Okay. Yes, I have in board item 25. Yes, you have your instructions, Mr. Neo.
My lord, we have filed the affidavit also.
You have filed it.
Yes, ma'am.
When? We don't have it. When did you file it?
Twenty-first of April, ma'am. 21st of April.
21st November. No, because it's in the last order, we said that no affidavit is filed.
We have filed the affidavit, ma'am. 21st of April, ma'am.
21st of April.
April,
Okay,
April.
okay.
Whatever it is not in the report, ma'am.
No, it's not there. This is not filed.
25.
There is no representation from the petitioner. Mr. S. Neok Leonard, standing also for the Secondary Education Department, submits that pursuant to order dated 24/3/2023, an affidavit in opposition has been filed on 21/4/2023. So we said affidavit is not on record. The registry shall tag said affidavit on record, list on
May I please see lordship?
3rd May.
Please see lordship. In this matter, your lordship, pertaining to respondent number 3, notice has not been issued upon us, your lordship. Respondent number 3.
The notice were issued long back.
But particularly, your lordship, respondent number 3, notice has not been issued yet, your lordship.
No, once you have standing counsel here, why we should notice be served? We issued a notice long back 29/10/2018.
Then our affidavit is not yet filed, your lordship. Kindly 3 weeks
No,
time.
that is your prerogative. You may file it, you may not file it. If you are waiting for an invitation card, you have to make an application before the President of India. Only the Law and Justice Department can, message a notice by way of an invitation card for you to.
My lord, perhaps, my lord, the Ramsar, that has not been shown in the cause list, my lord.
No, that we don't know. You see, respondent number 3 here is the mission director,
Yes, ma'am.
Rashtriya Madhyamik Shiksha Abhiyan. So notice has been issued. Correct.
Okay, yes.
Is that you know that the old saying, you can wake up a sleeping person, but a man who is awake, you can't wake him up. Correct? Okay. First of all, the aspirant for the respondent number 3 is also permitted to file affidavit in opposition within 2 weeks. List after 3 weeks.
Deeply obliged.
Yes, I take up the bail matters. First, because I'll be rising at 3 in 5 minutes time.
Infructuous matter. 26 has become infructuous.
Item
26.
26 infructuous. Mr. M. Datta for the petitioner. Elementary education will be there. Will be there. Mr. R. Mazumdar, elementary education. Yes.
29.
No, because I'll be rising in 5 minutes. I'll take up these 3 bill matters. I am not taking up any other matters. It will be rolled over.
29. My pleasure, Lordship. But earlier rejected by your Lordship, my lord. Earlier rejected by your Lordship.
Yes,
Not appropriate case diary and call for my lord as per the last order.
yes, you have it.
Yes, my lord. CD received, my lord. Here, my lord, earlier twice rejected by your Lordship, my lord.
Yes.
Involvement of the, my lord, all the petitioners, my lord. 4 petitioners are there, my lord. Okay. My
Please show me, I forgot the sequence. Just
lord,
take
there
that case diary.
is a murder case, my lord. Page 25, 24. Is the one earlier order. Subsequent order is at page 21, my lord. And my lord, regarding their involvement, my lord, it is reflected in page 22, my lord, paragraph 7.
Yes, I've seen that, but I'll need the case diary.
My lord, yes,
Okay.
Shri, my lord. OAQ statement, all these I have statement.
Okay, I'll go through the case diary and pass orders.
My lord, my only prayer, my lord, regarding my lord, petitioner number 4, my lord, Sanjeev Ali, my lord.
Yes,
Possibly, my lord, he was present there that I admitted, my lord, because they are all are relative, my lord. They quarrel between, my lord, the 2 family, my lord, regarding, my lord, road, my lord. And if your lordship goes page 15, my lord,
page 15.
page 15, my lord, the vernacular of the affair, my lord.
Yes,
These 2 sides, the name are mentioned, my lord.
yes,
The main quarrel is between, my lord, the first Asiton Bibi, my lord. These are the Ahid Ali's family, my lord. This quarrel between the informant and this family, my lord. And the right side, my lord, of the affair, my lord, the name mentioned, my lord, Rohima Bibi, that's Udu Ali, my lord. They are the, my lord, Udu Ali is the, my lord, cousin brother of the Ahid Ali, my lord. The quarrel is between Ahid Ali's family and the informant's family regarding road, my lord. My lord. And my lord, they are, my lord, all immediate neighbors, my lord. Hearing, my lord, hue and cry, my lord, they present there, my lord, that is admitted, my lord. And the, my lord, the fatal, my lord, my lord, that injury, my lord, that is given by one Akhtar Hussain, my lord. He is the cousin brother of the petitioner. Petitioner number 2, 3, 2, 4, my 1, 2, 1, 3, and 4, my lord.
you are saying this, this petitioner number 4,
My lord.
he's a neighbor.
Not neighbor, my lord. He is also the cousin brother of the main accused, my lord, Akhtar
Cousin
Hussain, my
brother.
lord. They are immediate neighbors, my lord. They are all, my lord, in the same, my lord, village, my lord. After hearing, my lord, hue and cry, Sanjeev Ali was also present there. The other petitioners also present there, my lord. Rohima Bibi is the, my lord.
But in the last order, we have recorded that
My lord,
you are involved in the assault. That is
yes,
what you have recorded.
my lord, in the last order, as per your lordship's order, my lord. 2 main accused, my lord. In the last order. One Akhtar, one Rajiv. Akhtar, my lord, attacked one Mansur. And at that time, Rohima Bibi and Manora Bibi, they caught that person and Mansur, and he loaded knife, my lord. And one Rajiv attacked Hamid. At that time, Zina Bibi helped him. So, my lord, all my lord, involved, my lord, it is reflected in the statement of the, my lord, Akhtar and Rajiv, my lord, statement.
No, 4 is Sanjeev
Sanjeev,
Ali.
yes, my lord. Sanjeev, my lord, yes, directly Sanjeev regarding, my lord, regarding the
That's
statement
what
of my lord,
he's
Rajiv.
discussing more on that Sanjeev Ali.
Sanjeev
That's
Ali.
why I have to look at the case diary.
Yes, my lord, that I leave it to lordship.
Okay.
Other are lady, my lord, and the fatal blow that is given by the Akhtar Hussain, my lord. They are the immediate neighbor, they present there, my lord. Kindly that part kindly be considered. And main
No,
person,
but
my lord.
for see, the difficulty is this PRS bail application.
That is
If it is a
yes,
regular
my
bail, we could have
My lord, yes, my lord. My lord.
understood, but it's a PRS bail.
And my lord, the main accused, my lord, the Akhtar Hussain, my lord. He has already been arrested, my lord. Page 18, my lord. I have the annex, the prodding letter also, my lord, of Akhtar Hussain, my lord.
That's okay.
He himself surrendered, my lord. That part may kindly be considered. Obliged, my lord.
Just a moment. This is item 29. Your name?
SM Mullah, my lord.
SM Mola. Okay.
I'm deeply obliged, my lord.
57.
May it please your lordship.
Yes.
Here lordship was pleased to ask the Thane APP to go to the LCM, my lord, scan copy, my lord. And to be precise, my lord, here, my lord, we have annexed the deposition, my lord, evidence before the court, my lord, of all the injured witnesses as well as the, my lord, family members of the deceased, my lord, and the informant, my lord. Because here, lordship, my lord, I'm coming for the last page, my lord, from the last page, if your lordship have a look, my lord, that earlier order, my lord. It starts from page 49, my lord. At that point of time, my lord, lordship was placed to reject it, my lord. Page 50, my lord, that is order dated 25/7/2022, my
Okay.
lord.
How many witnesses have been examined now?
Now, my lord,
Total?
seven witnesses, our instruction is that seven witnesses.
7 witnesses.
And those are the most vital witnesses, my lord. And
In the charge sheet, how many witnesses are there?
charge sheet
26.
23 or something, 26, my lord. 26 witnesses, my lord. And here, my lord. The next date is fixed for on 25/2023. For, my lord, there's a witness number 8, 9, and 10, my lord.
Just a moment.
Lordship, the rising percent.
When we have this listed tomorrow. We list it tomorrow because this has to be heard.
But tomorrow at 2 PM also.
You make a joint prayer at in the morning. In my orders, I am not fixing a time.
My lord,
Uh,
the subject of my lord, this court convenience also,
No, it's okay, but this is a bail. I have to take it up.
my lord.
It's a tied up matter. That's why tomorrow. Because I don't have time today to hear more. Due to paucity of time, matter could not be heard today. This is matter on. This is tomorrow is 27th.
Now we'll come at 2 PM, then lordship convenience. We'll come at 2 PM tomorrow.
Both of you agree to a time and come.
Yes, ma'am.
Take it up.
Obliged.
So this is, I have to hear the APP. The allegation here is that the persons refused to join that organization and
Madam.
therefore they were beaten up and
Yes,
assaulted.
Yes, lord.
That is the, I have to hear it.
Yes.
Otherwise, I'll be burdening myself by taking this case diary home that I wanted.
But 7 witnesses, all, and we have annexed all the deposition, my lord.
That I've noted.
My lord.
Okay.
Obliged.
Much of the.
Yes. Yes, cattle preservation.
Yes, my lord. CD received, my lord.
Yes.
But his involvement is there, my lord. He is that petitioner is, my lord, transporting, my lord, cow from the different districts to Assam, my lord, without any, my lord, valid, my lord, Chalan, my lord. In the name of
Petition is not there.
petitioner is not there.
Take it up day after tomorrow then.
My lord, on Friday, my lord.
The Council for Petition is absent on call. Mr. K.K. Parashar, the APP is present. And so this is matters from the adjourned today, just on 28. Other matters will be rolled over.
Finally, item number 28, I pray for a date only, my lord, in any date,
Court must will take care of it.
my lord. But where is my this thing? It is a democratic question.